Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 31, 39, 39.
39. Yes.
Your Lordship, I need some more 3 weeks time. Affidavit was same for waiting. And this is a bringing the effect district. Normally it takes a lot of time by the postal department.
You are for a respondent.
Yeah, respondent number 3 to 10, state respondent,
Item number 39.
39.
Who's for a petitioner?
And long. I'm here to, I don't want more already. 39 within the narrow.
Check.
39.
Level.
37 or 39?
39.
Mine is 37.
39.
No objection, my lord. In my course list, it is 37, so there was a confusion.
You are Long Kumar,
Yes, my lord, I'm long Kohima, my lord, in long Kohima.
not Mr. I am Long Kumar. If you for a petitioner. The learned counsel, Mr. If you for respondents,
Yeah, state respondent.
respondent 1 to 3,
3 to 10,
3 to 10,
state respondent.
state respondent. Praise for some time to respond to the petition. After hearing both sides, the prayer is allowed. When do you want it?
3 weeks time.
Least after 3 weeks.
What's going for respondent to my appearance may kindly be shown.
Also heard, Mr.
More Jamir Lodge.
It may put a respondent number
2 Lodge.
2.
Your lordship, I'd like to mention item number 50.
Item number 50,
50. Let the matter come up after 4 weeks.
4 weeks. The learned counsel, Mr. What is your name?
Petitioner,
What is your name?
Nang Saya.
Appearing on behalf of the learned senior counsel, Mr. C.T. Jamil.
Yes, lordship.
Praise for an adjournment on personal grounds. After hearing both sides, the prayer is allowed. Least after 4 weeks for hearing.
All right.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item 40, Your Lordship. Your Lordship, I'm mentioning on behalf of my colleague who's representing the state, Your Lordship. Here she's here to receive instructions. So Your Lordship make. 40.
You go for a petition.
Yes, my lord, I'm the petitioner, my lord.
Do you have any objection?
Yes, my lord, they are taking so long time.
Your Lordship,
So let this matter be as a fixed case, my lord.
Your Lordship, here she's here to receive instructions in item 40, Your Lordship. So 3 weeks time may be granted to receive instructions and to file affidavit, Your Lordship.
The learned counsel students. Appearing state respondent. Submits that she needs some time to take instructions. I have also heard the learned counsel, Mr. Jayden and Bulliard, appearing for the petitioner. The prayer of the state respondent is allowed. At least up to 2 weeks,
3 weeks, Your Lordship.
3 weeks.
Much obliged, Your Lordship.
Last please.
May I please, Your Lordship? I beg to mention item number 49 on behalf of my senior Joshua Shaki. Kindly grant us 2 weeks time, Lordship. Our affidavit is ready, additional affidavit is ready, but we have sent to obtain signature from the department.
The learned counsel MS.
Okay, Lily Su,
uh,
on behalf of Joshua Shaki.
Appearing on behalf of the learned government advocate, Mr. Joshua Sheki,
Yes, Lordship.
submits that she needs some time to take instructions. I have also had MS.
Alitosu, on behalf of Wadi Jamir.
Your Lordship, if I may, Lordship. Your Lordship, I'm appearing on behalf of the states, Your Lordship. Your Lordship, I may also be allowed some time to file one additional affidavit, Your Lordship,
On the other hand, the learned counsel MS.
in the
So,
holy, Your Lordship.
Appearing for the state respondent prays for some time to file an additional affidavit. After hearing both sides, the prayers are allowed. At least after,
2 weeks, Lordship.
just after 2 weeks.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes,
I would like to mention item number 26 on behalf of my senior Z Jumomi.
26.
You know,
Lordship, regarding this matter, on the last occasion, I've instructed
Hmm.
to place some record. Accordingly, Lordship, I have received. So, Lordship, let the matter be listed accordingly.
next week, if possible. We just received it this morning, Your Lordship.
The learned counsel, Mr.
Newton, on behalf of my senior Z Jumomi.
Newton,
Yes,
appearing on behalf of Mr. Jed,
Z Jumomi.
prays for an adjournment. On the other hand, the learned counsel MS,
Pichano,
appearing for the state respondent, submits that she has already filed the necessary documents. And after hearing both sides, the matter stands adjourned.
and Lordship, I was also instructed to place on some record.
You have placed it.
No, Lordship, I have received, so Lordship, I may be allowed to place.
Look at the next date, at least after 2 weeks. The hearing, the matter is adjourned, at least after 3 weeks, 2 weeks, 3 weeks.
Much obliged.
Also, I'd like to mention item number 29, Lordship.
Yes.
So I'm yet to file affidavit in reply, and maybe given the 3 weeks time, Lordship.
The learned counsel, Mr. Muajami,
Lordship.
Muajami. Appearing for the petitioner submits that he needs some time. What you want to file?
Affidavit in reply, Lordship.
Some time to file the affidavit in reply in respect to the affidavit filed by the state respondents. I have also heard the learned counsel, Mr.
Nangami, Lordship.
Shangami, appearing for the state respondent. The prayer, Mr. Jamir, is allowed. The this matter again after
3 weeks, Lordship.
3 weeks.
Much obliged, Lordship.
Obliged. Lordship, I beg to mention item number 48 on behalf of my senior and Moshe.
48.
Yes, Lordship. If this matter can be taken up after 2 weeks
You
Thanks,
are
my-
state respondent. Your senior
and Moshe
and
is,
Mojui,
is 48G.
48. The Learned Counsel MS,
Yellow hair.
K. Lohe, appearing on behalf of the learned
And Moshe.
government advocate.
Your lordship, no, your lordship, she's mentioning on behalf of the accountant general, your lordship.
Oh. Appearing on behalf of the accountant general. Praised for some time. Why do you want the adjournment?
My senior is indisposed.
Oh. That the learned conducting counsel, Mr. N. Mojui, Mozhui, is indisposed today.
Lordship, I'm counsel for a petitioner,
What is your name?
Vikono Kiso.
I have also heard Ms. Vikono Kisu, appearing for the petitioner. The prayer of the state respondent is allowed. Least after
2 weeks.
2 weeks.
Okay, Lordship.
May it please your lordship. Lordship, I beg to mention item number 41. Lordship, I have instruction to appear for respondent number 5 in this case. So kindly grant me 3 weeks to file my counter. And I'll be filing my power in 3 days' time, lordship.
The learned counsel, Mr.
TKJ,
PKG. Appearing for the respondent number 5.
respondent number 5.
5 submits that he has appeared today for the first time and he needs some time to file the reply. To that effect, the learned counsel prays for some time. I have also heard MS
Asnla Longkumar.
appearing for the petitioner. The prayer of the learned counsel is allowed. When do you want it?
3 weeks' time,
Least
lordship.
after 3 weeks.
Obliged, lordship.
Please, your lordship, I beg to mention item 27, your lordship. Here I'm mentioning on behalf of my colleague Livika, who's representing the state, your lordship. She's yet to file counter, so kindly grant 3 weeks' time.
The learned counsel for the state respondent prays for some time to file the reply. I have also heard Mr. Muazami, the learned counsel appearing for the petitioner. After hearing both sides, the prayer of the state respondent is allowed. When he will file,
After 3 weeks, your
at
lordship.
least after 3 weeks.
Lordship, I'm for respondent number 4 here.
I have also heard Mr.
PKJ,
TK appearing for the respondent number
4.
4.
Much obliged, your lordship.
My please, Lordship,
Yes.
I beg to mention item number 32
32.
on behalf of Mosam Lordship.
Yes. 32 is
Yes,
listed
32.
with 33 also.
Lordship 32 and 33. On behalf of Mosam. The state is here to receive instructions, so kindly grant 3 weeks time to file affidavit.
You're for the state respondent.
Lordship,
The learned counsel MS
Pichano.
Pichano. Appearing for the state respondent, prays for some time. I have also heard Mr. Appearing for the petitioner. The matter stands adjourned accordingly. When do you want it?
Lordship, on for the petitioner in item number 33,
I have
WPC 182,
I have also heard Mr.
Fosseco, Lordship.
Appearing for the petitioner. When do you want it? When you will file the reply? After 2 weeks.
Lordship, 3 weeks.
The prayer of the state respondent is allowed, least after 3 weeks.
Obliged, Lord.
For motion, item number 1 to 11.
Please, your lordship.
This is for correction.
Yes, your lordship.
Do you have any objection?
No, Lordship. I'm appearing for respondents 1, 2, and 3. I have, yes, Lordship, in all the petitions. I have no objections.
In the I,
4 to 7.
heard Mr.
I am Jin, your lordship.
IMG. Appearing for the applicant. Heard Mr.
Sindhyanga, Lordship.
Sandhya. Appearing for the respondents.
1, 2, and 3.
1, 2, and 3. Where this interlocutory application has been filed for changing the title of respondent number 9 in the connected writ petition. It has been stated that it has been mentioned the it has been mentioned in the writ petition that the title of respondent number 9 is to be changed from fake village, PHEK, fake village to Losami village. There. The aforesaid correction seems to be a typographical error. Therefore, the error stands corrected. The petitioner has make the corrections in the title page of the connected writ petition. With the aforesaid direction, the IS stands disposed of. From item number 1 to 12, same order.
No, your lordship, the name of the village may change. In some of the cases, the name of the village is different again. And your lordship, I may be directed to file the amended cost title and then take steps upon the newly implemented respondents.
The petitioners will file a correct writ petition having correct addresses. In item number 2 is for Fag village to Losami village.
Yes, your lordship.
Item number 3,
Same, Losami village, back to Losami
Same.
village, yes.
then item number 4.
That's
different.
Futsuro village, yes, from Fake village to Futsuro village.
Item number. This is item number 4.
Yes, your lordship.
In item number 4, it will be from Fake village to Kuseru.
Yes, yes, your lordship.
In item number 5,
From Fake village to Purpa village.
item number 5, from Fake village to Porba village.
Yes, your lordship.
In item number 6,
From Fake village to Folami village, your lordship.
from Fake village to
Fulami village.
Polami village. It is there in the title page. Make the corrections. Fake village. All will be corrected. After filing of the corrected title page of the writ petition, the same shall be listed again next week.
Lordship, I may be allowed to file the amended cost title and then direction may be issued to take notice upon the corrected correspondence, your lordship.
First of all, file the corrected one. After that, order will be passed for notice.
Your lordship. Much obliged, your lordship.
For motion, item numbers 12 to 20.
Same matter, Your Lordship, it's a connected matter. For correction.
From Egg village to Losami village. All are same,
Yes, Your Lordship.
all are same.
Yes, Your Lordship. Otherwise, Your Lordship, I can supply a copy of the checklist, the correction, and then the steno can type it up, Your Lordship.
Much
Much
obliged.
obliged.
For correction. That will be-
For motion item number 21.
Maybe his lordship. Lordship, here the petitioner is aggrieved by the impugn order passed by the jointly passed by the DB scored Mezipema and the political assistant to DC court office of the Deputy Commissioner Chumukidima, Lordship. Lordship, here the fact of the dispute is that the petitioner has sometime like in 1995 has sold the land to the performer respondent, his paddy fields, Lordship. The paddy field, Lordship, the sale deed. The sale deed, Lordship, is at the page 36, Lordship. Page 36, Lordship. The type copy is at page 37. Lordship.
Yes.
Lordship has got it, Lordship. I Shri Haulai Movam village has sold my paddy field, Lordship. The here Haula Movan is the petitioner, Lordship. Yes, sell a paddy field to Sri Kinikrul Koso of so and so village in the year 1995. Kinikrul Koso, that is the performer respondent, Lordship. And subsequently, the paddy field, the land was bought by one Mr. Visashil, that is the respondent 5. But Lordship, the respondent 5 is claiming that the petitioner has, the respondent number 5 has also purchased the Jum land as well as the dry land. But Lordship, so the petitioner by the one judgment passed by the Chakrama GB's Union, Lordship. The case was taken up before the Chakrama GB's Union, and the order was passed on 12/5/2022. That is at page 38, Lordship. Page 38, Lordship. As Lordship got it. Lordship, here the operative part, judgment. Considering the above stated points, that CGBA courts has come to conclusion that since there was no valid proof document enabling to possess the dry land portion by the complainant, the said dry land cannot be dragged into the sale deed agreement of the Steris field. As such, the respondent's right on the possession of the said dry land cannot be shaken. Lordship, this was the judgment passed by the GB's court of the Chakrama, Lordship. But Lordship, the respondent number 5, aggrieved by the judgment of this Chakrama, has approached the ADC court, Medzipema Chumikidima District. And Lordship, the political assistant to DC, jointly with the DB's court, that is at page number 40, Lordship, has passed this decision order dated 29/10/2024, Lordship. Operative part is at page number 41, Lordship. I may be allowed to read, Lordship. 41 decision. The said Jum plantation of the teak, gamari tree, etc. in the dispute site at Movan village will be divided into 2 equal halves towards Medzipema will go to the respondent number 4, Visashel Retso. There is a respondent 5, Lordship. And the other part towards Movan village will go to Sri Haulal of Movan village, Lordship. This is the petitioner. Lordship, here, Lordship, the issue is that, Lordship, the judgment of this honorable court which has been referred to a larger bench, Lordship, that is at page 16, passed in 16, Lordship, but page 16. Page 16, Lordship,
Yes.
passed in the Civil Revision 5 of 2020, where Lordship, the Honorable Court has placed the issue where the decision or a judgment of the GB's court will be placed either before the judicial officer or the DC. Lordship. Lordship, the operative part is at page 35, Lordship. Lordship may come to page 35.
Yes.
Lordship, in view of the reasons discussed herein above, I respectfully disagree with the view expressed in the decision taken by a coordinate bench in the judgment of Mr. P. Viejo Aomi Supra, and therefore judicial discipline and propriety demands that the matter be placed before the Honorable Chief Justice for referring the issue to a larger bench. Accordingly, the registry is directed to place the matter before the Honorable Chief Justice for his Lordship's further consideration. Lordship may also come to page 33. Page 33, Lordship.
Yes.
Paragraph 27. Thus, it is apparent that two parallel courts are functioning and are permitted in the state of Nagaland. One of the customary courts made by the executive and other village authorities having jurisdiction as provided under the provisions of Rules 937 by following the procedure laid down in the state rules 1937. The other courts are general courts created by the virtue of Civil Courts Act 1887, CRPC and CPC, and made by the members of the Judicial Service under the Nagaland Judicial Service Act 2006. The procedure followed to conduct of business and jurisdiction of the general courts are as mandated in CPC and CRPC, and for customary courts, it is the rules of 1937. Therefore, in absence of any enactment conferring jurisdiction upon general courts to act as an appellate authority against the decision of customary courts, the general court cannot assume jurisdiction by the virtue of notification of dated 22/8/2008. In view of the aforesaid decision and reasons, this court is of the considerate opinion that the principal district and session judge, Dimapur, has rightly passed the impugned order by not entertaining the appeal preferred by the petitioner hearing. However, Lordship, next page, paragraph 30. However, as stated herein above, in a similar situation, a contrary view was expressed by a coordinate bench in its judgment order dated 8/6/2017, passed in Civil Revision 6 of 2015. The learned counsel for the petitioners also relied on the decision to buttress his argument. The ratio laid down in the aforesaid judgment is reflected at paragraph 7, which is quoted herein below. From the contents of Rule 24 and 31 of the Rules of Administration of Justice and Police in Nagaland, Third Amendment Act 1984, given above, there is no doubt that village councils do enjoy certain powers to adjudicate civil disputes, particularly in matters relating to customary laws, and their decisions are appealable before the Deputy Commissioner or his assistants. Further, reading together to the minutes of the meetings held at the residence of the Honorable Chief Justice of the High Court and the notification issued by the Department of Justice and Law, Nagaland, it appears that decision for total separation of judiciary from executive in phased manner has been taken and implemented on the same has been stated with the district of Dimapur. In view of this change, it has taken place. The power of Deputy Commissioner under Rule 31 of Rules of Administration of Justice and Police in Nagaland 937 has to be understood and transferred to the district judges, especially in respect of the district of Dimapur. Therefore, the learned district Judge Dimapur should have admitted the appeal and decided the same on merit. The judgment of the High Court rendered in the case of Registrar General Gauhati High Court versus Union of India and others in WPC 5873 of 2016, reported in 2013. 2006, my apologies, Lord, 2006, reported in 2013 for JLT 1109, does not in any way block the jurisdiction of the Court of District Judge Dimapur in adjudicating such cases. In view of what has been stated, the impugned judgment and order of the learned district judge dated 23/4/2015 passed in first appeal number 23/2020 is squashed and set aside. Accordingly, the district judge, Dimapur, shall admit the appeal and dispose the same on merit, Lordship. At page 35, Lordship, in considering, in view of the what has been expressed by the Honorable Court, in view of the reasons discussed here and above, I respectfully disagree with the view expressed and decision taken by the coordinate bench in the judgment of Mr. P. Dioho Aomi, Super, and therefore judicial discipline and proceedings demands that the matter be placed before the Honorable Chief Justice for referring the issue to a larger bench. Lordship, here the Civil Revision 5 of 2020, along with other similar cases, is yet to be decided by the division bench, Lordship, of this Honorable Court, Lordship. And in view of in the absence of the jurisdiction where the order of a GB should be before appealable before the DC or the judicial officer, district judge. In view of that, Lordship, since no decision has been taken as of now till date, Lordship, Lordship, the petitioner has approached the Honorable Court to protect the property which has been divided by a court having no jurisdiction to decide on the matter, Lordship. That is by the DB's court, Medzipema, jointly with the political system of DC, Lordship. The Honorable the petition is before this Honorable Court to interfere with the impugn order and for quashing and setting aside, and in the interim to stay the impugn order dated 29/10/2024, Lordship. That is the case of the petitioner, Lordship.
Who is for a state respondent? You're for a state respondent.
Yes, yes, my lord.
There are four state respondents. You were agreeing for all four.
Yes.
Uh-huh. 1, 2, 3, 4.
You want to reply?
Your lordship, page 35. My friend just read off. The last paragraph. Accordingly, the registrar is directed to place the matter before the Honorable Chief Justice for his lordship's further consideration. Now, this matter, clubbed up with another Civil Revision 6, was been sent back to this page by the Honorable Chief Justice. Now, the division bench of this court is hearing this matter. This matter relates to the, as your lordship is well aware, it relates to the jurisdiction of the court. And then this customary court, village court, DC and its assistance court, all these are under consideration by this court. So my suggestion is let this matter also be clubbed up with this.
Other similar petitions.
Lord, those matters which are under consideration by the division bench of this court.
Lordship, my humble prayer is that till the decision is made by this Honorable Court, by the division bench of this Honorable Court, Lordship, my prayer is that the impugn order be stayed, Lordship.
What is your reply to that?
Since
He's asking for stay of the impugned order.
Since the DB's court, jointly by the political system of DC, doesn't have the jurisdiction, Lordship.
What is your reply to that?
And regard to the interim lordship, I have nothing to say. But the main barrier, that is the jurisdiction. For adjudication of that matter, lordship, this matter may be clubbed up with the other, which is under consideration. But in regard to the interim, I have nothing to say.
Little learned counsel, Mr.
Oseko, Lordship.
Oseko, for the petitioner. All right, Mr. You are government advocate,
I'm Moa Inches, Senior Government Advocate.
senior government.
Lordship, I will be representing respondent number 1, 2, 3, and 4.
APA for respondents 1, 2, 3, and 4. Yeah. This application under Article 226 of the Constitution of India revolves around the question as to who, that is, the deputy commissioner and the district judge is entitled to hear the appeal against a judgment passed by GB,
Lordship, GB.
passed by GB,
GB Court.
GB court. A coordinate bench of this court in civil revision petition number 5 of 2020 has directed that the matter should be placed before the Honorable Chief Justice for constituting a larger bench to decide this issue. The learned senior government advocate has submitted that there are some other petitions also on the same issue. And the present petition should be clubbed with the other similar petitions. Yeah. The learned counsel for the petitioner has agreed to that proposal. Accordingly, registry is hereby directed to list this writ petition along with other similar writ petitions
Lordship, pending before the division bench.
pending before a division bench of this court. There. The learned counsel for the petitioner, where is the impugned order, page number?
Page number 40, Lordship.
The learned counsel for the petitioner submits that till the issue is decided by a division bench of this court, his property needs to be protected. After hearing both sides, the prayer is allowed. It is hereby directed that the order passed by the ADC,
Lordship, the second part, DB's court, Mizipema, joined court with the political assistant to DC. This is an order joining by his
passed by
father.
the DB's court.
Mizipema.
Medzifema, page number 40. Medzifema. In case number 70 of 2022.
2224.
Case number 70 stroke 2022 stroke dash 2024 shall remain state until further order.
Lordship, order is dated 29/10/2024, Lordship.
Order dated
29/10/2024.
order dated 29
10/2024, Lordship.
2024 passed by the
Passed by the DB's court, Mizipema,
MSD FEMA
joint court with the political assistant to DC
Joint-
Dimapur. Lordship, not Dimapur, Chumukidima. The political assistant to DC court,
With the political assistant
to DC court, Office of the Deputy Commissioner, Chumukidima, Nagaland.
Chumkudima, Nagaland, in case number 70 stroke 2022-2024. It is page number 40. Page number 40.
Highly obliged.
For motion item number 22.
Yes,
May it please your lordship.
yes.
Your lordship, I am challenging the release order dated 1st November 2024 for wrongly releasing the petitioner from the post of the Zila Sainik Welfare Officer. Now, my lord,
He was prematurely retired.
my lord,
He was retired on completion of 5 years of service.
yes, your lordship. And as far as the appointment, the condition of appointment is concerned, he is to serve till 60 years. So, my lord, the new guidelines, 13th August 2024 was actually, it was released by the government of India. It's a guideline. And my lord, that is for those who have reached 60 years and their engagement, further engagement can be for another 5 years up to 65 years. Not only that, this guideline is not applicable to the present petitioner. The other wrong that has been committed by the responding authorities is that my client has been this notification was retrospectively applied on my client. And my lord, laws are prospective in nature. It cannot be retrospectively applied.
You are for respondents 1 to 4. You are?
Will it be 1, 2, and 3?
1, 2, 3.
4. Oh, you are not
No, my,
agreeing for
I'm for 1 to 3.
1 to 4.
Yes.
4 is the Directorate of Sainik Welfare. Do they have a separate council?
I don't know.
They don't have any council.
That they are also part of the state authorities.
And who is for Union of India?
Union of India, we have a copy.
My lord, 1 to 4
My lord,
for this thing.
You are 1 to 4.
Yes, ma'am.
Then who is for 5?
5, your lordship, there are 2 union councils. I don't know whether they are around. We can serve a copy if they would accept it. Your lord.
Serve a copy to him.
My lord,
Heard, Mr.
Joshua, your lordship.
Joshua
Shaki,
Sheki,
my lord.
appearing for the petitioner. Heard, Mr.
LT Sangam,
LP Sandam,
additional AG.
the learned additional Advocate General,
Yes, ma'am.
appearing for the respondents 1 to 4. The petitioner is directed to serve a notice to the learned council representing the respondent number 5, Union of India
Your lordship, CGC,
or CGC,
my lord.
learned CGC.
My lord, in the course of the day,
In the course of the day.
my lord.
Then you want to find any reply?
Yes, ma'am. 3 weeks time may be granted.
The learned additional Advocate General prays for 3 weeks' time to file a reply. After hearing both sides, the prayer of the learned additional Advocate General is allowed. This matter after 3 weeks.
My lord, the interim, at least the release order, 1st November. Till the next returnable date, my lord.
Till the next returnable date, your lordship, the interim prayer may not be considered.
Oh, my lord, if they do not want to agree to the interim, then we can fix it after 2-3 days, your lordship, within this week also.
First of all, let them file their replies. CGC is also not present.
Now, my lord, one thing which is very clear, which my lord may kindly appreciate is laws cannot be retrospectively applied, your lordship.
Correct that.
My lord.
The new rule has been, there is a latest law that will not be applied to older persons.
Yes, your lordship, because my client has only 48 years. It's applicable only to 6 people who have completed 60 years and can be employed for another 5 years. That is on honorarium basis, Your Lordship. So that is not applicable to my client, Your Lordship. And he's the only one that has been affected, Your Lordship. Similarly situated person, there are many officers. My client is the only targeted person, my lord. So given the level of unfairness,
Para. The learned counsel for the petitioner praised for interim order. The learned petitioner Advocate General has objected to it. But I have considered the submissions made by the learned counsels of both sides. Uh, After hearing both sides, it is hereby directed that the petitioner shall not be released from signing board,
my lord.
signing board till returnable date. The new guidelines shall not be implemented in respect of the present petitioner for the time being.
My lord. Highly obliged, Your Lordship.
Maybe Lordship. Lordship, in item 21, Lordship, notice was not issued to the respondent number 5, Lordship.
Item number 21.
Lordship, yes. There are 5 respondents, so
Item number 21, the petitioner shall take steps for service of notice upon the remaining respondents
Lordship, and also,
by registered post AD.
Lordship. Obliged, my lord.
For admission, item numbers 23 and 24.
My pleasure, Your Lordship.
Yes.
Lordship, this matters for increment and consequent benefit of pay of the petitioners. Lordship, however, the state has not yet filed their counter affidavit in the matter.
You want to file a reply?
No, Lordship, the state is yet to file their
Lordship,
affidavit.
kindly grant 3 weeks time to file affidavit.
What the learned counsel, Mr.
Manjong Konyak,
Majuk Koyak,
on behalf of my senior, Mr. Ezimomi.
appearing for the petitioner. Petitioners. The learned counsel MS.
Lordship, on behalf of Vizimo,
Okay. What is your name?
Pichano,
The learned counsel MS P Chano,
Lordship,
appearing on behalf of Mr.
Vizimo,
V Jimumi,
Lordship,
the learned government advocate, praised for some time to file the affidavit in opposition. After hearing both sides, the prayer is allowed. When you will file?
Lordship, 3 weeks time will be granted, Lordship.
The list after 3 weeks.
I pledge.
Along with item number 24.
For admission, item number 25.
Yes,
Your Lordship, here I'm yet to receive affidavit in opposition.
you are for the petitioner or the respondent.
I'm for the petitioner, Your Lordship.
That means they have filed the affidavit in opposition, you want to file a reply.
No, Your Lordship, they are yet to file their counter affidavit.
Who is for the respondent?
Vijimomi.
Vijimumi. Same. The learned counsel MS, I forgot your name.
Pichano,
P Chano, appearing on behalf of the learned government advocate, Mr. P Jimomi, praised for some time to file the affidavit in opposition. I have also heard MS
Ace Jillian.
H Jede,
Ace Jillian.
appearing for the petitioner. The prayer of the state respondent is allowed, list after 3 weeks.
Lordship, I
Like,
pledge.
For admission, item number 28.
The respondent, has the respondent filed the affidavit?
Yes, my lord, they are filing affidavit. By filing the affidavit, they are willing to release the salary, pending salary of the petitioner in 3 installments within 6 months.
Do you agree to that?
Yes,
Then it can be disposed of today.
yes, we can dispose of the petition to the lordship.
Or Mr. S. Longkumar, appearing for the N. Longkumar, appearing for the petitioner. Or Mr.
I, Jamir,
I. Jamil, appearing for the state respondents
for university lordship.
for the university.
Yes.
Where is your affidavit? Mr. Longkumar has submitted that the respondent university has agreed to pay the arrears salary of the petitioner.
Yes, and EPF also.
Arrears salary as well as EPF
Yes,
of the petitioner in 3 installments. Stop. Mr. Longkumar submits that he is in agreement with the university on that point. The Mr. Longkumar further submits that on the basis of the affidavit filed by the university, the matter can be disposed of today with an appropriate order to that effect. There, after considering the submissions made by the learned counsels on both sides, the Global Open University Nagaland is directed to pay the arrears salary and the EPF to the petitioner within in 3 installments. When we will start paying from December?
Lordship,
From December.
December lordship.
The payment of installments shall start from the month of December 2024. Will you pay it per month or
Lordship in 3 installment within a period of 6 months.
the payment of installments shall be completed within next 6 months, starting from December 2024.
Lordship.
With the aforesaid direction, the present petition stands disposed.
yes.
Obliged, lordship.
For admission, item numbers 30 and 31.
Yes,
Wait, please, your lordship.
yes.
Your lordship, these matters are fixed for admission hearing. Can we start, your lordship?
Yes.
Give me good admissions. Your lordship, in WPC number 216 of 2021. This was the first writ petition filed.
Yes.
There are 2 category writ petitions, your lordship. If your lordship can come to 216 of 2021.
216.
216.
Yes.
Lordship, we can come to the prayers in my petition at page 29. the subject matter first, Your Lordship. First,
Just a minute. Not finding the petition.
216 of 2021.
Where is the petition? Petition reply,
There is an amended petition, my lord.
amended petition. Page number 29.
No, first, my lord, page 14, the subject matter of the case, Your Lordship. Page 14.
Yes,
Your Lordship can come to paragraph 4. May I read, my lord?
yes.
Just so that the facts are clear. That the National Highways and Infrastructure Development Corporation Limited issued an NIT dated 24/12/2019. The aforesaid notice relates to a part of the road construction project from Kohima in the Kohima district to Jesami in Manipur. This road falls under National Highway 29, old National Highway 150. The contract is on EPC mode and for package 1 under the said project. 5, that in the state, a novel approach has been adopted for executing road projects. Through the district administration, landowners, villagers along the route of road projects have been told that apart from damage compensation, now this is the issue, Your Lordship. Apart from damage compensation, no compensation whatsoever will be paid for the use of land for road construction. In fact, the landowners, villagers have been categorically told that demands for land compensation will result in the cancellation of the road projects. 6, that the damage compensation coined by the respondents is the compensation for damage to houses, property, etc. This damage compensation excludes compensation for land. The assessment thereof is also not on the basis of the procedure prescribed by law, but an arbitrary assessment made by the respondents. So this is the case, my lord. This is basically the case.
The road constructed or no? Not constructed.
It is ongoing, Your Lordship.
Ongoing.
And when the petition was moved, Your Lordship, an interim order was passed by the Honorable Court directing the lands of the petitioners to be surveyed. Order dated. Possibly 18/11/21, Your Lordship. 18 order dated 18/11.
The compensation for the land was given.
No, not given. Only what they term as damage compensation that has been assessed. For my group of petitioners, we have not accepted that. We are saying that if land has to be acquired, it has to be acquired in terms of the National Highways Act 1956, which Your Lordship is aware. There can be no derogation from the procedure prescribed by law. That is my case, ma'am. So an interim order was passed, Your Lordship, on 18/11. On 18/11, that the land should be surveyed. 18. An order dated 18/11/2021, Your Lordship.
21.
Yes, madam.
Please find out.
18/11/2021.
18/11/2021. Oh, yes, yes. That's not
18/11.
Yes.
May I read, my lord?
Yes.
Heard the learned counsels appearing for the parties, learned counsel for the petitioners, etc., etc. Learned counsel for the NHRECL, etc. Considering the submission of the learned counsels, I am of the opinion that it is imperative to conduct survey of the land belonging to the petitioners, which are stated to be affected by the construction of National Highway 29 Package 1 before drastic changes happens on the land due to the construction. Therefore, the respondents, particularly respondent number 6, is directed to conduct survey of the lands of the petitioners within a period of 1 month from the date of the receipt of a copy of this order. So the survey has been done.
Hmm.
The survey has been done. Now, if I may take your lordship. I filed a bundle of separately with all these statutory instruments which are relevant for this purpose, your lordship. Bundle A. Bundle A. Bundle A. With all the acts, your lordship. I've compiled them together in a compilation. It's like this. Excuse me. It's like this.
The last one. On the backside, there A is written. No.
Can you check the other file?
Other files?
Can you check the other file? WBC 50? Is there? It might be there also. Front. Doesn't seem to be on file. Then you, in that case, your lordship, if you can, from the bare acts, we can come to the National Highways Act 1956.
Yes, what is the section?
Firstly, your lordship, section 3, the section 1, short title and commencement,
National Highway.
at page 3. You have the same edition.
National Highway Rules.
National Highways Act 1956.
Yes,
Your lordship got it?
yes,
Section 1, short title and commencement.
yes,
Clause 2, it extends to the whole of India. Your lordship has got that?
yes.
Then definitions, your lordship,
Hmm.
competent authority, then 3A,
Hmm.
power to acquire any land.
Hmm.
As well as where the central government is satisfied that for a public purpose, any land is required for the building, maintenance, management, or operation of a national highway or part thereof, it may by notification in the official gazette declare its intention to acquire such land. So two things here first, your lordship.
Hmm.
Firstly, it is the central government which acquires the land. And if it has an intention to build national highways, it must declare its intention to acquire such land. The first step. Then, of course, the other procedures about acquisition around, your lordship is well aware of that. It's not necessary to go into that.
Yes.
Now, the ground has been taken, lordship, because multiple affidavits have been filed. So if I can come straight to the point, without going into too many of the details. Now, the ground has been taken that National Highways Act is not applicable. A very funded ground has been taken. We are building scores of national highways in the state. And the state has now filed an affidavit as well as the NHLDCL. And they are saying National Highways Act is not applicable. A very, very difficult position to understand, your lordship. For that purpose, if I may take your lordship to the Nagaland Code, Volume 1. Nagaland Code, Volume 1. Nagaland Code, Volume 1.
Yes.
Has the lordship got it?
Yes.
I hope that is the 2004 edition, my lord. Is it the
This is
2004 edition?
2004 edition.
Yes. Now, if your lordship will come to page 463. Page 463. Page 463.
Yes.
And the schedule 4. This is list of central acts in force in erstwhile Naga Hills, Twensang area, immediately before 1st December 1963. This is very important, Your Lordship. Now, Your Lordship can turn to page Schedule 5. Schedule 5 now, Your Lordship. Schedule 5. This is in batches of years, Your Lordship, according to the enactments.
5.
Yes, Schedule 5. List of central acts in force in erstwhile Naga Hills, Twensang area immediately before 1st December 1963. Now, under Schedule 5, if Your Lordship would.
The Twensing area are list of central acts in force in erstwhile Naga Hills,
Yes, madam.
Twensang area immediately before.
Before 1st December 1963. That is the statehood. The statehood day, Your Lordship. 1st December 1963 is the date on which Nagaland came into existence.
Yes.
Now, if Your Lordship will come to page 478. Page 478. At serial number 48. As serial number 48. It is the number of the act.
National Highways Act.
National Highways Act 1956.
It was applicable before
the state of Nagaland came into existence.
Yes.
It was already applicable. Now, if you can, Lordship can turn to the State of Nagaland Act, which is now at page. State of Nagaland Act is at page 493. In the same volume, Your Lordship. Page 493. Is Lordship got it?
Yes.
The State of Nagaland Act 1962. Now, if you can, Lordship can come to page section 26. At page 502.
Yes.
Section 26. Continuance of existing laws and their adaptation. All laws in force immediately before the appointed day in the Naga Hills Twensang area shall continue to be in force in the state of Nagaland until altered, repealed, or amended by a competent legislature or other competent authority. So therefore, National Highways Act applies. No doubt about that, Your Lordship. So it is very wrong on the part of the state as well as the NHLE to say that the National Highways Act does not apply. Then not only that, Your Lordship, the Land Acquisition Act 1894 has been amended. Now we have the Right to Fair Compensation Act. NHLE as well as the state is saying the Right to Fair Compensation Act of 2013 does not apply. In this regard, Your Lordship, kindly in the same volume again. In the same volume again, now this is part at page 427. Page 427.
Yes.
So part 8 contains the various schedules, and the schedules are divided in terms of the years, Lordship. So part 8. So this is the first schedule, and Your Lordship can turn to page 437.
Yes.
436.
Yes.
1894.
Land Acquisition Act.
Land Acquisition Act 1894 applies to the state of Nagaland. So therefore, it is again wrong for the state as well as the NHLE to say that the Right to Fair Compensation Act does not apply. Not only that, Your Lordship, we have an act called the Nagaland Land Acquisition and Requisition Act. This is more or less a copy of provisions of the Land Acquisition Act of 1894. But there are certain sections here which refer to the Land Acquisition Act of 1894. For example, section 6.
Just a minute.
Section 6.
Oh, yes.
Yes. And section 6, subsection 3 at the bottom, Your Lordship. Subject to the provisions of this act, on such vesting, that is after a notification has been issued, the provisions of the Land Acquisition Act with rules framed thereunder shall, so far as may be, apply to such lands. Then also, Your Lordship, at in section 9,
Yes.
speedy acquisition of land in certain cases. Then subsection 2, when the compensation has been determined under subsection 1, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act. So this is the principles with which acquisition is to be assessed in terms of the 1894 Act. Has the Lordship got that?
Subsection 1 and you were referring to subsection 2.
In section 9, Your Lordship, subsection 2.
Section 9,
Subsection 2. When the compensation has been determined, has the Lordship got that?
The collector shall.
No, section 9, Your Lordship. No, compensation, sorry, Your Lordship. Sure, section 11.
Oh, section 11,
Yeah,
yes.
section 11. Your Lordship.
Subject to the previous.
Yes, compensation. Yes. And subsection 2. When the compensation has been determined under subsection 1, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act of 1894. So even in terms of the act of the state, in the matter of assessment of compensation, the provisions of 1894 Act would apply. So when the 1894 Act has been amended and a new act been repealed and a new act brought in place of the old act, the new act automatically applies. That is a settled principle of law. And in fact, section 11, this particular section has been interpreted by the Honorable Court, Lordship, and there is a decision on this point. So it is also a covered case. And I place that decision for your Lordship's consideration. Lordship, I'm taking this Honorable Court to the provision so that there's no confusion first. Otherwise, as far as the factual part is concerned, there is no dispute that the provisions of the National Highways Act 1956, the Right to Fair Compensation Act of 2013 have not been followed. No dispute at all. Now, Lordship, this is 2022, 3 GLT at 632, page 632. Page 632, can we go straight to section 8? Paragraph 8, Your Lordship, at page 635.
Yes.
May I read, my lord?
Yes.
Section 11(2), the one we were referring to earlier, Lordship, of the Act of 1965 is relevant for the purpose of the instant dispute, more particularly in view of the contentions made by the learned's senior additional AG. Subsection 2 of section 11 stipulates that when compensation has been determined, has to be determined under section 11(1) of the Act of 1965, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act 1894. What has been done by section 11(2) of the Act of 1965 is that section 11 of the Land Acquisition Act 1894 was incorporated to the provisions of the Act of 1965 on the principle or the basis of the principle which is known as legislation by incorporation. The legislation by incorporation is a legislative device for the sake of convenience in order to avoid verbatim reproduction of the provisions of the earlier act into the later act. Once the incorporation is made, the provisions of the incorporated statute becomes an integral part of the statute in which it is transferred, and thereafter, there is no need to refer to the statute from which the incorporation is made, and any subsequent amendment in it has no effect on the incorporating statute. Then, paragraph 9. Accordingly, by virtue of the said incorporation of section 11 of the Land Acquisition Act 1894, for the manner of inquiry into the award by the collector has stipulated in section 11 of the Act 1894 becomes a part of the Act of 1965. Relevant at this stage to take note of that the collector in terms of section 11(1) of the said Act shall make an award under his hand in relation to the true area of the land, the compensation on which, in his opinion, should be allowed for the land. 3, apportionment of the said compensation among all the persons known or believed to be interested in the land, of whom or of whose claims the collector has information, whether or not they have respectively appeared before him. Now, if I can pause there for a moment, Your Lordship. This case is in relation to National Highway 29 from Dimapur to Chumukdima. There, the four lane there. Same thing happened here also, Your Lordship. Just taking the stand that National Highways, there is a certain road reservation is required. Without acquiring the land, National Highway was constructed. That was the issue here, Your Lordship. Then, Lordship, we can also see paragraph 13, 14, and 16. 13, 14, and 16. Can we go straight to paragraph 13? In view of the impugned order whereby it was observed seeking assessment of compensation under the provisions of the Act of 2013 was outside the scope of the said reference code, this code therefore has to deal with the legality of the said observations. As already stated, so this is the Right to Fair Compensation Act, Lordship, 2013. That has to deal with the legality of the said observations. As already stated here and above, in terms of the reference, there is no mention as to under what provisions the compensation is to be assessed. The terms of reference dated 27/4/2016, more particularly as seal number 1, seal number D, as quoted here and above, is as to whether the landowner village is entitled for any enhanced compensation, and if so, on what basis and what are the amounts. Under such circumstances, to restrict the compensation in terms of the Act 1965 on the basis that the reference was made under the provisions of section 12(1) of the Act 1965 is in the opinion of this court is incorrect and misconceived. So, sorry, Your Lordship, this is not about Highway 29. That's another case. I'll bring down that also. This is with regard to assessment of compensation, whether it should be under the Act of 1894, the 1965 Act of the State, or the Right to Fair Compensation 2013. So, this honorable court held that it must be under the by the doctrine of the legislation by incorporation. The Act of 2013 also applies in the state. This is one, Your Lordship. Now, with respect to National Highway 29, this is the case, Your Lordship. This is the case. You go straight to the operative portion, which begins at paragraph 26.
This is regarding the road from Kohima to Chumukdima.
From Dimapur town to Chumukdima. That stretch of the National Highway, Your Lordship. The 4-lane. And as I was saying, Your Lordship, just relying on the road reservation, which is kept for national highways, without actually acquiring the land, the highway was constructed. So the landowners came to this honorable court. Paragraph 26, my lord.
Yes.
Your Lordship, got it? Paragraph 26. In the backdrop of the above, the question therefore arises for consideration is as to whether the respondent authorities, in the name of reserving the right of way, can transgress upon the pata lands of the petitioners without payment of any compensation. At this stage, it may also be relevant to take note that in the state of Nagaland, there are some lands which are government lands, whereupon cadastral survey has been done. In respect to such lands, the Assam Land and Revenue Regulations 1886 is applicable. Upon such government lands, the Deputy Commissioner, upon receiving proposals from the competent authority, grants patas. Section 12 of the Assam Land and Revenue Regulations 1886 empowers the state government to make rules, amongst others, for disposal of government lands by way of grants of lease as otherwise of such lands. On the basis of Section 12 of the said regulation, settlement rules have been framed. Rule 2D of the rules defines a periodic lease to mean, except in case of a town land, a lease granted for a period longer than 1 year. In case of town lands, a lease for a period longer than 3 years. It has also been mentioned that insofar it is consistent with any restrictions, conditions, and limitations contained herein, a periodic lease, the term of which is not less than 10 years, conveys to the lessee the rights of a landowner as defined in the regulation. In the instant case, some of the petitioners herein have been allotted a periodic lease for a period of more than 10 years. In this regard, if this court further takes into account Rule 64 of the settlement rules, it stipulates that a periodic lease for townlands means a lease which is granted for more than 3 years and which, if granted for not less than 10 years, conveys a permanent, that is heritable and transferable right of use and occupancy in the land, subject always to the due payment of land revenue and local taxes, cesses or rates, to the reservation in favor of government of all quarries, mines, mineral oils, and all buried treasure, to the absolute forfeiture of the lessee's interest in the land on his refusal to take the renewal of the lease on the expiry of its term, and to the special conditions of any engagement into which the landholder may have entered with the government. Therefore, it would be seen that a person who holds a periodic lease or a patta issued by the Deputy Commissioner has a permanent, heritable, and transferable right for use and occupancy of the land in question. 27. This court also takes into account that in the state of Nagaland, all lands are not government lands. There are lands which are not cadastrally surveyed. These lands are private lands. In respect of such lands, government of Nagaland do not collect any revenue over such lands. However, transfer of such lands takes place with the consent of the village council, and written records of such transfer are being maintained by the village council in terms with section 15(1)(4) of the Nagaland Village and Area Council Act 1978. On the basis of such records, the village council issues certificates acknowledging the rights of the purchasers. Now, if I can pause here again for a moment, Your Lordship, the reference to the village councils. Now, whenever developmental projects are initiated through village lands, no objection certificates are sought from the village councils. So in these cases also, Your Lordship, no objection certificates were given by the village councils. Now, what the state and the NHIDCL have interpreted these NOCs to mean is that by these NOCs, lands have been transferred. Absolutely wrong proposition in law, Your Lordship. That is also a big mistake. And 28, in the instant case, some of the lands fall within the cadastrally surveyed government lands and some lands are private lands. The documents which have been enclosed to the instant petition are documents whereby the petitioners have claimed the rights over their respective lands on the basis of pattas, periodic leases being issued by the Deputy Commissioner with the approval of the government, or certificates being issued by the village council and commonly known as village pattas. In the said backdrop, if this court takes into consideration the submission made by the learned AG, additional AG, to the effect that as the government is the owner of the land in question, the government has the right to reserve the land in the name of right of way, this submission, if allowed, in the opinion of this court, would amount to defeating the rights of the persons who had been vested with rights on the basis of issuance of pattas, periodic leases by the government to the Deputy Commissioner, or the rights acquired by the persons on the basis of pattas being issued by the village council. This court, while initially hearing the matter on 16/3/22, inquired as to on what basis the respondent authorities have reserved 27 meters, that is 30.5 meters from the center of the road, and in that regard had directed the Deputy Commissioner Dimapur to file an affidavit. There is no material produced to show that the land reserve for right of way in question was originally 27 meters, or there was any acquisition of the rights from the persons who are enjoying periodic lease or rights acquired on the basis of the village council certificates. From the said affidavits, the details which have already been mentioned here and above, it transpires that the Secretary to the Government of Nagaland Works and Housing Department had requested the Deputy Commissioner Dimapur to issue a notification reserving 30 meters of land width along its section of the highway as road reserve, and also take necessary action to hand over 27 meters width of this section to Project Sewak for undertaking the work. This communication was issued on 10/2/1999. Most surprisingly, the Deputy Commissioner Dimapur, without following any due process, issued a notification on 28/4/1999, notifying for general information of the public, landowners from Purana Bazar, Dimapur to Chumukidima, that 30 meters width of the road is hereby kept as road reserve along National Highway 39, 1110 to 123 kilometers, section of the highway, for four laning of the portion of the highway. In doing so, the Deputy Commissioner have not at all taken into account that the rights of the persons, the landowners, which stood vested on the basis of periodic lease being issued, or on the basis of the village council certificates being issued, would be affected. No doubt, the appropriate government authority would have the power to acquire lands on account of public interest, but in doing so, if it affects the vested rights of the people, landowners, the same can only be done by following the procedure established by law. This aspect of the matter is clear from the Constitution mandate as stipulated under Article 300A of the Constitution. In this regard, court would like to refer to a judgment of the Supreme Court in Vidya Devi 2022 SCC 569, wherein the Supreme Court, after taking note of various judgments previously rendered by the said court, held that the appellant could not have been forcefully dispossessed of her property without any authority, legal sanction, and without following the due process of law, and depriving her payment for just compensation being the fundamental right on the date of forceful possession in 1967. It was further observed that in a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without a sanction of law. Further, it was observed that a state being a welfare state governed by the rule of law cannot arrogate to itself a status beyond what is provided in the Constitution. Placing reliance in the judgment of State of Haryana, 2011, 10 SCC 404, the Supreme Court in the said judgment in the case Vidya Devi observed that the right to property is now considered to be not only a constitutional or statutory right, but also a human right. Subsequent to that, in another judgment of the Supreme Court in DB Basnet, 2024 SCC 572, wherein the Supreme Court took up for consideration the question in the concerned facts as to whether the state had taken up process for acquisition and has followed the same in accordance with law, in paragraphs 13, 14, and 15, the Supreme Court held that it is the burden of the state to prove that there has been any acquisition of land as well as compensation of the case. This is the point, Your Lordship. The state has proved that there has been acquisition and compensation has been paid in accordance with law. As there were no documents placed on record as to whether there was any acquisition, and the law being expropriatory in character, the Supreme Court, after taking note of various judgments, observed that the petitioners therein were entitled to not only mean profits, but also compensation if the state still wanted to retain the lands. Paragraphs 13, 14, and 15, as well as 19 and 20 being relevant, are being quoted here and below. 13. That brings us to the question whether the process of acquisition had been followed in accordance with law. No notification has been shown to us of the intent to acquire land under Section 4. So, Your Lordship, the notification under Section 4 under the National Highways Act. Nothing. Same case, the facts are more or less the same, Your Lordship, even here. Has been shown to us of the intent to acquire land under Section 4 or any other declaration thereafter. In fact, what is claimed before us, as also before the course below, is that no records are available in respect of the acquisition process. This absolutely puts the respondent state in a difficult situation, which was sought to be got over not only by relying on the consent having been obtained for acquisition of land and the compensation having been paid as determined. So, Lordship, the Supreme Court's decision is not necessary to go through the entire. This is a reliance by this honorable court. Then, paragraph 31. Lordship will come to paragraph 31. In the backdrop of the above law laid down by the Supreme Court, and taking into account the facts involved wherein the state of Nagaland has failed to show any document that the road reserved for right of way was initially 27 meters, and it being a specific case that by way of notification dated 28/4/1990, the road reserved for right of way was enlarged to 30 meters, and no materials produced to the effect how the road reserve was enlarged without acquiring the land, Your Lordship. This court is of the opinion that the respondent authorities, more particularly the Deputy Commissioner Dimapur, could not have enlarged the right of way reserving the existing road to 30 meters of width as reserved along National Highway 39, 110 to 123 kilometers section of the highway for forwarding without following the due process procedure of law. The action of the respondent authorities of reserving in the name of right of way without showing the excess land was brought within the right of way, therefore stands vitiated. No acquisition, therefore it stands vitiated. 32. This court, page 3, paragraph 32. This court, while dictating the judgment, had put a specific query upon the learned additional AG, as well as the learned counsel for respondent number 2, as whether they would like to retain the land. It has been submitted that the four-laning road has already been constructed, and as such, the question of returning the land to the landowners if there was any transgression to their rights do not arise. Further, the learned AAG also submitted that this court would not be in a position to decide as to what compensation, if any, has to be paid, taking into account that it would be require the fact finding as to whether the petitioners at all have any rights, and if at all the rights have been affected. 33. This court duly agrees with the said submissions, and that this court would not be in a position to decide as to whether the petitioners have any right over the lands, or for that matter, whether there has been transgression to their rights on account of reserving widening of the road to 27 meters. This court, having already observed that the Deputy Commissioner could not have enlarged the road without following the due process of law and without payment of compensation, in the interest of justice, directs the concerned Deputy Commissioner to carry out the fact-finding inquiry. The learned additional AG has also drawn the attention of this court to the fact that the entire stretch of land in National Highway 39 from 1110 to 123 kilometers section falls within the domain of the Deputy Commissioner Chumigidama as well as the Deputy Commissioner Dimapur. Considering above, this court therefore disposes of the instant writ petition with the following observations and directions. 1. This court declares that the action of the Deputy Commissioner to enlarge the width of the road reserve to 27 meters, that is 13.5 meters from the center in the stretch of road, that is from National Highway 39 from 1110 to 123 kilometers section of the highway from Dimapur to Chumidima without carrying out any acquisition, and more particularly the notification dated 28/4/1989 consequently stands vitiated for not following the due process. The landowners whose lands fall within 13.5 meters from the center of the road in the said stretch of road, if affected, would be entitled to compensation as mandated by law. Two, taking into account that this court is not in a position to decide how much land and which land of each of the petitioners or any of the landowners have been affected, it would require a fact-finding inquiry. This court directs that the petitioners to submit their claims, including the claims for destruction of their properties along with their land documents and other documents for verification before the Deputy Commissioner Dimapur and or Deputy Commissioner Chumidima, before whose jurisdiction the land falls within 45 days from the date of the instant order. Taking into account that only 230 petitioners have filed the incident petition and there may be other landowners who may have been affected, this court further directs the Deputy Commissioner Dimapur as well as the Deputy Commissioner Chumidima to issue a notice in news daily of wide circulation calling for any claims along with their documents for verification. The same should be done within 20 days from the date of the instant order. 3. On the basis of the claims as well as the documents so submitted, the Deputy Commissioner Dimapur and or Deputy Commissioner Chumidima and or any person to whom the Deputy Commissioner deems fit to entrust but not below the rank of an ADC shall verify the said claims on the basis of the documents submitted within a period of 6 months from the date of the submission of the claims by the persons interested. In filing the said claims, the petitioners are, as well as the landowners, would be at liberty to also submit claims regarding their loss suffered on account of demolition of their properties. 4. Upon verification, if it is found that the petitioners or landowners have been affected on account of enlarging the width of NH 39, that is 27 meters, that is 13.5 meters from the center of the road in the stretch of road from National Highway 39 from 1110 to 123 kilometers, section of the highway from Dimapur to Chumukidima. And in that case, the Deputy Commissioner Dimapur and or the Deputy Commissioner Chumukidima, in consultation with the state of Nagaland, as well as respondent number 2, shall initiate proceeding for acquisition under the National Highways Act 1956 by following the due process of law. So, Your Lordship, a clear direction that if the highway is to be constructed, National Highway 1956 should be followed. So in that view, this case is already covered. If they want to build the national highways, they must acquire in terms of the National Highways Act 1956. No two ways about it, my lord. It is made clear that if in the circumstances, the petitioners and all the landowners are aggrieved by the fact-finding inquiry by the Office of the Deputy Commissioner, the petitioner and all the landowners will be at liberty to initiate proceedings under the Code of Civil Procedure 1908. 6. If the petitioners, however, are aggrieved by the action of the respondents in respect to the entitlement and quantum of compensation, the petitioners can avail the remedies available under the National Highways Act 1956. So therefore, if the so-called assessment, which was allowed to be done by the deputy commissioners of the 2 districts, if the petitioners were not satisfied with that, they could revert back to the provisions of the National Highways Act 1956. National Highways Act 1956 applies. Petitioners in this case, if they're not satisfied with the compensation, they can revert back to the provisions of the Highways. So it is very clear, Lordship, that National Highways Act 1956 applies. So if National Highways Act 1956 applies in these 2 cases, Lordship, can the state proceed? Can the NHLECL proceed? Can the MORTH proceed without complying with the provisions of the National Highways Act 1956? This is the short point in law, Your Lordship. Now, these two decisions, Your Lordship, Right to Fair Compensation Act applies. National Highways Act 1956 applies. Now, there is another decision now, Your Lordship. Now, 2024 1 GLT. 2024 1 GLT. I am sure the state is going to press this judgment for their benefit, and it would be a remiss on my part if I did not place this judgment before Your Lordship. In this judgment, Your Lordship, 2024 1 GLT, page 750. A single judge of this honorable court has held that the Right to Fair Compensation Act is not applicable because it has to be adopted by the state of Nagaland in terms of Article 371A. This is the decision, Your Lordship. But this decision does not take into account the earlier decision passed by a coordinate bench. So therefore, this is per incurium, Your Lordship. This judgment is per incurium. And it also does not take into account that the Land Acquisition Act 1894 was enforced in the state. So a statutory provision has also not been taken into account. Therefore, this judgment is per incurium. And on this authority, Your Lordship, may I rely on the decision of the Supreme Court. What is a per incurium judgment? a judgment which does not take into account an already binding precedent or a statutory provision of law. Lordship, 2017, 16 SCC.
Yes.
16 SCC, page 680. If you can go straight to paragraph 16, Your Lordship.
Yes.
May I read, Your Lord?
Yes.
In state of Bihar, etc., an earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction, considering the question later, on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter, but it would not be a reason to say that a decision was rendered per interim and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of coordinate jurisdiction. So there's already an earlier decision saying that the right to fair compensation is applicable. Then the court has further ruled, easy course of saying that earlier decision was rendered per interim is not permissible, and the matter will have to be resolved only in two ways, either to follow the earlier decision or refer the matter to a larger bench. That is the only way. That is judicial discipline, Your Lordship. Your Lordship is very aware of that. Then, Lordship, can go to paragraph 20. In the context, we may fruitfully note what has been stated in Pradeep Chandra Parija. In the said case, the Constitution bench was dealing with a situation where the two-judge bench, disagreeing with the three-judge bench decision, directed the matter to be placed before a larger bench of 5 judges of this court. In that scenario, the Constitution bench stated, in our view, judicial discipline and propriety demands that a bench of 2 learned judges should follow a decision of a bench of 3 learned judges. But if a bench of 2 learned judges concludes that an earlier judgment of 3 learned judges is so very incorrect that in no circumstances can it be followed, the proper course for it to adopt is to refer the matter before it to a bench of 3 learned judges, setting out, as has been done here, the reason why it could not agree with the earlier judgment. So if at all, the subsequent bench of the Honorable Court disagreed with the earlier judgment, the only course was to refer it to a larger bench.
But in this judgment, that judgment was not referred.
It was not referred to at all. So straight away, this Honorable Court can hold that it is for inquiry. Then, the Lordship can paragraph 21. Chandra Prakash, another constitution bench dealing with the concept of precedence, stated thus: the doctrine of binding precedent is of utmost importance in the administration of our judicial system. It promotes certainty and consistency in judicial decisions. Judicial consistency promotes confidence in the system. Therefore, there is this need for consistency in the enunciation of legal principles in a decision of this court. It is in the above context that this court, as Singh, has held that the pronouncement of law by a division bench of this court is binding on the division bench of the same or smaller number of judges. So one coordinate bench judgment is binding on the other coordinate bench. Then paragraph 22. In Sandhya Education Society, it has been observed that judicial decorum and discipline is paramount, and therefore the coordinate bench has to respect the judgments and orders passed by another coordinate bench. In such and such, the court dwelt upon the issue, which should be the consequent effect of the later decision which had been rendered without noticing the earlier decisions. The court noted that the observations in Raghuveer Singh and produced a passage from Indian Oil Limited, which is to the following effect. The division bench of the High Court in Municipal Corporation Indore was clearly in error in taking the view that the decision of this court in Ratna Prabhu was not binding on it. In doing so, the division bench of the High Court did something which even a later co-equal bench of this court did not and could not do. We can go to paragraph 23 also, Your Lordship. Paragraph 23 also. It was also stated.
The paragraph?
Paragraph 23.
23, yes.
It is also stated what has been expressed in Raghuveer Singh, We are of opinion that a pronouncement of law by a division bench of this court is binding on a division bench of the same or smaller number of judges, and in order that such decision be binding, it is not necessary that it should be a decision rendered by the full court or a constitutional bench of this court. 24, paragraph 24. In Rajesh, the three-judge bench had delivered a judgment on 12/4/13. The purpose of stating that the date is that it has been delivered after the pronouncement made in Reshma Kumari case. On the perusal of the decision in Rajesh, we find that an attempt has been made to explain what the two-judge bench has stated in Santosh Devi. Since the court in Santosh Devi actually intended to follow the principle in the case of salaried persons as laid down in Salary Rama, and to make it applicable also to self-employed persons, not necessary, Your Lordship. Other authorities are not very relevant, Your Lordship. But there was already a decision of a coordinate bench, and that is a binding procedure. That has not been taken into consideration. Therefore, the subsequent decision is a per incurium judgment, and it did not bother this honorable court as far as this case is concerned. Now, more decisions on acquisition, Your Lordship. What happens if the procedure is not followed? 2011, 10 ACC, which is referred to in the National Highways case, Your Lordship. Yes, Your Lordship, 2011, 10 SCC at paragraph 33.
Page number 404.
Page number 404. Yes, my lord. Paragraph 33. Lordship, for this portion, Lordship, I have made a list of authorities that called out the principle. I can file that, Lordship. Paragraph 33. The principle is the right to property is now considered to be not only a constitutional right, but also a human right.
Yes.
Then the next one, 2017, 11 SCC 601. This is the Tata Nano case, Your Lordship. The West Bengal case, both the Tata Nano plant. Yes, Your Lordship. And in this case, at paragraphs 88 and 89, 2017, 11 SCC. 2017, 11 SCC 601. At paragraphs 88 and 89. I'm sure I've colored the principle in the paper that I submitted to you. Page 659. The principle here is, Your Lordship, if the manner of doing a particular act is prescribed under any statute, the act must be done in that matter or not at all. Acquisition proceedings in derogation of the Land Acquisition Act are perverse, illegal, and void ab initio. Such exercise of power by the state government for the acquisition of land cannot be allowed under any circumstance.
The paragraph?
Paragraph 88 is 9.
Yes.
Can I read, my lord?
Yes.
It is also a well-settled principle of law that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. In Burgess, etc., 31, it is the basic principle of law, long settled, that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. The origin of this rule is traceable to the decision in Taylor versus Taylor, which was followed by Lord Roche, etc., etc. Where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. This rule has since been approved by this court in Rao Shiv Bahadur Singh, again in Deep Chand. These cases were considered by a three-judge bench in so-and-so cases. This rule has since been applied to the exercise of jurisdiction by courts and has also been recognized as a salutary principle of administrative law. Then paragraph 89. In the instant case, what makes the acquisition proceedings perverse is not the fact that the lands were needed for setting up an automobile industry, which would help to generate employment as well as promote socio-economic development in the state. But what makes the acquisition proceedings perverse is that the procedure as laid down under Part 7 of the Land Acquisition Act, read with the rules, was not followed by the state government. The acquisition of land for and at the instance of a company was sought to be disguised as acquisition of land for public purposes in order to circumvent compliance with the mandatory provisions of Part 7 of the Land Acquisition Act. This action of the state government is grossly perverse and illegal and void ab initio in law, and such an exercise of power by the state government for acquisition of land cannot be allowed under any circumstances. So acquisition of land in violation of the provisions of the Act cannot be permitted, Your Lordship. Cannot be permitted. So the law is settled, Your Lordship. Now, with these principles of law in mind, Your Lordship, if you can go straight to the petition again, we can come back to the petition now. 216 of 2021. WPC 216 of 2021.
Yes, yes.
Now we can go to the prayers now, my lord, at page 28.
Yes.
The first prayer, prayer A, direct the respondents to acquire the lands of the petitioners required for the construction of the road project under package 1 of National Highway 29 in terms of the provisions of the National Highways Act 1956, the right to fair compensation and transparency, the Land Acquisition Act of 2013, and the Land Acquisition and Acquisition Act of 1965. I have mentioned both the acts, and there is a reason for this, Your Lordship. If Your Lordship will recall, in the Nagaland Land Acquisition Act 1965, there is a reference to the Land Acquisition Act. B, caution set aside, the minutes bearing number such and such dated 2011-2018, page 66. Now, if you can come to page 66, Your Lordship, this is the minutes. Page 66. This is the manner by which the so-called damage compensation was assessed. Minutes of the meetings held on 2011-2015 at 1 p.m. in the conference hall of the Chief Secretary in connection with the work, Kohima Jasami Road 2019. So firstly, Your Lordship will note, this is not an acquisition proceeding. It's just a meeting. Chief Secretary, IS welcomed all the members present in the meeting and initiated the discussion. Secretary Works and Housing and General Manager NHACL, Dimapur briefed about the background of the Kohima Jasami Road. Kohima Jasami Road was declared National Highway in 2000, but it was never upgraded. MORTH has taken a decision to develop the road as a 2-lane road with paved shoulder and will be upgraded to NH standards. MORTH awarded the DPR preparation to MS Feedback, etc., and has done the DPR preparation in consultation with the BRO as the road stretch was under BRO and the approval authority being MORTH. Stage 1 to 3 of the DPR has been approved by the ministry, and stage 4, draft DPR and final DPR has been submitted to NHACL, and the same is under scrutiny. The road's 0 point at Kohima is at PSF Camp Kohima Town and it will terminate at Lanier Bridge near Jasami. The remaining road portion, approximately 12 kilometers from Lanier Bridge in Manipur, will be done by another consultant appointed by NHACL Manipur. The road has been divided into 6 packages and no realignment has been proposed. The total length of the road is 112.308 kilometers. In rural area and urban area will be 24.0 meters and 20 meters respectively as per IRS SP 73. There are 7 minor bridges and 443 culverts. Deputy Commissioner Peck requested to give compensation for vacant building plot within town area and increase the compensation rate for plantation area. So this is what is being decided, Your Lordship. These are the decisions which are being relied upon. Request to give compensation for vacant building plot within town area and increase the compensation rate for plantations. So building plots and compensations. Leaders of Fusro requested enhancement in land compensation rate in town areas, and Hurumi, Kohima village leader requested for construction of retaining wall within the village area and to look into the irrigated terrace field along with the roadside. Lazame village asked for compensation of paddy fields on both sides of the road and also requested to build a retaining wall along the village area as the church and the school are above the road. Messalumi village leader inquired about damage compensation beyond ROW. After deliberation, the following decisions were arrived at. 1, the consultant needs to obtain forest clearance from DFO, PAC, and DFO Kohima. Wildlife clearance is not required as the nearest wildlife sanctuary is 6.5 kilometers away. 3, now this is important, Lordship. No land acquisition compensation will be paid. Only damage to property compensation will be paid. So this is where the problems arise, Lordship. 4, provision for dumping site, mud disposal site has been earmarked during preparation of DPR and should be included in the DPR. Consultants will take 1 month period to finalize the center point and PROW, after which DC PLEG and DC Kohima will be approached to obtain NOC from the affected owners. Shifting of utilities will be done in consultation with district administration and departments concerned, namely Power Department, PHE Department, etc. The meeting concluded with a vote of thanks from the chair. Now, what is important here, Your Lordship? Firstly, there is no mention of any landowners being present. No mention of any. It's at some sort of an official level. And also, no, this meeting minutes does not disclose the presence of any person from Kohima village. We are from Kohima village, Your Lordship. We are from Kohima village. And page 68 is a list of attendees. Not very clear, Your Lordship. Not very clear. The type copy is at page 70. And type copy of list of attendees is also at page 72. So whether, Your Lordship, whether anyone represented from Kohima village immaterial, it is not an acquisition proceeding. First point. Secondly, none of the landowners was present in this meeting. This is the first meeting, Your Lordship. Then this is followed by, Your Lordship, at page 29 now, the next minutes. This is minutes dated 1/2/2020.
Page number?
At page 74.
Yes.
This is dated 1st February 2020. A meeting of the Kohima Jessamy 2-lane road widening project was held on 31st January 2020 at the office chamber of the Deputy Commissioner Kohima at 10 a.m. on 31 January 2020 under the chairmanship of the Deputy Commissioner. The Deputy Commissioner Kohima apprised all present of the DPR presentation made by the consultants on 6 December 2019 and also reminded the village council of the submission of the NOC for the said project. Again, here, Your Lordship, earlier we were referring to village council, Your Lordship. Village councils give NOC to say that they have no objection for developmental projects within the territories of the village, within the lands of the village. The Deputy Commissioner stressed the need for the development of the road project at the earliest. It was agreed by all the villages in principle that there is no objection to the said project and shall fully cooperate for the developmental activities. The meeting ended with thanks from the chair. So again, here also two things, Your Lordship. This is not an acquisition proceeding. This is not an acquisition proceeding. This is a meeting of certain functionaries of the state, including some representatives of the village councils. Then, and next one is, Your Lordship, no objection certificate. Just to show what the no objection certificate is, Your Lordship. At page 75.
Yes.
This is dated 1st February 2020. This is from the village, this is from the Deputy Commissioner. This is to certify that the district administration of Kohima has no objection for construction of 2-lane Kohima Jessamy Road, which shall be utilized for Kohima Jessamy 2-lane project only. The land is free from all encumbrances. Wrong certificate, Your Lordship. It is not free from encumbrances. By giving this NOC, the Deputy Commissioner cannot take away our lands and give it to the NIC resale. Then next is at page 76, next to G. Now, this is a very interesting letter, Your Lordship. And in fact, this letter is the foundation of all the problems we have insofar as the construction of national highways is concerned. This is dated 6 August 2020, and this is a DO letter. This is also not a very formal letter. It is a DO letter, and it is written by the Chief Secretary. Type copies at page 77. And this is a letter written to the managing director of the National Highways Infrastructure Development Corporation Limited. Your Lordship, you can see that at page 76. At the bottom of the page, the endorsee is the managing director of NHRECL. Type copy, if you can go to the type copy, Your Lordship, the type copy is more clear. If I may read from the type copy. At page 77.
Yes.
Dear Shri Pathak, I take this opportunity to convey my deep appreciation for the sincere efforts taken by your team on road development projects in the state. Despite setbacks due to the COVID-19 pandemic, the indomitable spirit put in by the NHRECL has been most commendable. I would like to draw your attention to the necessity of development of Kohima Bypass and Kohima Mau Road as discussed with you on 30/7/2020. Subsequent to the downgrading of the Kohima Bypass project from 4-lane to 2-lane, it has emerged that farmers affected by the project are reluctant to part with their land without commensurate compensation as cost of land around the capital city is assessed to be high. After a series of discussions by administration with the landowners, it has become difficult to completely ignore the land compensation part on the Kohima bypass project. Appropriately, keeping in view of our existing policy of non-applicability of land compensation on road projects where existing alignments are adopted for development, a conscious decision was taken to include the compensation of land only for the greenfield portion of this project. As you are already aware, making available land free of cost for two-lane road development projects on existing alignments still being applied to all NHIDCL projects in the state. You will appreciate that this bypass is imperative in view of the heavy vehicular traffic to and from Imphal on National Highway 29 through Kohima city, which has increased many folds due to load restriction imposed on Imphal Jiripam Road, leading to heavy congestion within the city. It will also be appreciated that with the aim to have faster development of interstate connectivity projects, provisions of land free of cost for two-lane projects in Nagaland has been adopted, unlike that in other states. So this is a unilateral adoption by the state. No consent of the landowners. Therefore, minor variation of land policy with respect to greenfield projects needs to be considered at par with policies of land compensation being adopted among other neighboring states. May I therefore request you to consider compensation in lieu of land for Kohima bypass portion passing through greenfield and apply free land policy on alignment passing through existing road where only damage compensation is to be altered. I also assure that judicious land rates will be applied within the normative cost in the state for this project. In view of this, I request your personal intervention for speedy implementation of Kohima bypass. Also, the Kohima Mao section may kindly be taken up in order to provide a seamless corridor. Now, Your Lordship, an interesting development took place. The state perhaps came to the realization that the policy, the so-called policy they had adopted was contrary to law, and they have withdrawn this letter. Not highly, Lordship, because it was placed on record by the learned Ancient Legion when the matter was being heard previously. This is a notification dated 28 November 2023. May I read, my lord?
Yes.
In pursuance of the cabinet conveyed by number CAB dated 9/11/23, and in order to ensure smooth and expeditious development of national highway projects in the state, it is notified that henceforth land compensation and damage compensation shall be paid to individual community landowners for construction of all national highways declared by the MORTH in the state. Henceforth, land required for road construction of national highway projects and additional land right of way required for development beyond the existing road in the present national highway shall come under the purview of this notification. This is issued in supersession of DO number dated 6/8/2020. So this is the letter which I was earlier reading, Your Lordship. And minutes of meeting held on 2011-2018 issued by dated nil November 2018. This notification shall come into force with immediate effect. So this letter of the Chief Secretary has been superseded. And this notification sounds good, Your Lordship. It sounds good. Sounds very good. It sounds for it looks to be for the interest of the public. But this notification does not say that it should be done in accordance with the provisions of the National Highways Act. Because all along, the state respondents and the NHIDC are under the impression that they can take lands without resorting to the provisions of the National Highways Act. That is impermissible. The only good thing about this letter is that it has corrected its misconceptions about how national highways should be.
The government has agreed that compensation is to be paid.
Yes, in addition to damage compensation, so-called damage compensation. But it must be under the provisions of the National Highways Act. Then the next one, Your Lordship. Page 116. Page 116. It's not very legible. The type copy is at page 117.
Yes.
This is one of those so-called NOCs, Your Lordship. This is dated 4/2/2020. This is to certify that the government of Nagaland plans to construct two-lane road from Kohima to Jesami. Therefore, the government have no objection for developing the jurisdiction. Very clear, Your Lordship. The village council simply states that it has no objection to development within the village. This is not a grant or a conveyance or a transfer of property to the NHIDCL or district. Very clear, Your Lordship. The what is most interesting, Your Lordship, is that the NHID said itself has brought out the MOTH, my lord. The MOTH itself has brought out comprehensive instructions about how national highways should be built and the process by which the national highways should be built. And that, Your Lordship, will find in page 35. 35. Yes. Now, this document contains instructions to all the states. 28 December 2017, to chief secretaries to all states, governments, administrators of union territories. Then the procedure, Your Lordship, contains the entire procedure. How compensation is to be paid, how land is to be acquired, how compensation is to be assessed. It's a lengthy document, Your Lordship, but it is a detailed instruction in terms of the National Highways Act and the Right to Fair Compensation Act of 2013. Detailed instructions. So why is this not being followed in the state of Nagaland? That is the moot question, Your Lordship. So therefore, insofar as the petitions are concerned, we are ready to part with the lands. We have given our lands, but we must be compensated. We can only, our lands can only be taken by the procedure establishment, through the procedure establishment. That is our case, Your Lordship. And in the other case, in similar, Your Lordship, but in the other case, here a very interesting fact. Firstly, Your Lordship, the facts, WBC 50. Yes. Paragraph 6, the facts, my lord. Page 26. Yes. So in this case also, Your Lordship, by order dated 29/3, Lordship, kindly note the order. 29/3/23. 22, my lord. 29/3/22. Yes. Yes. 29/3, my lord. Yes. Straight to the operative portion, my lord. The case of the petitioners is that for the construction of two-lane Kohima bypass road connecting National Highway 29, National Highway 150, and National Highway 61, the state authorities have started surveying the villages where the petitioners' land are situated. The petitioners complain that such survey has been started without their knowledge. The further case with the petitioners is that the lands are sought to be acquired without following due process of law. Accordingly, the present petition is filed. An interim prayer is also made by the petitioners to the effect that the respondents be directed not to commence any work without proper survey of the land. Such prayer is being made by the petitioners on the ground that once the lands are taken over without any survey, it will be a difficult situation to calculate the acquisition compensation. The learned AAG, Governor of Nagaland, on instruction has submitted that a notification dated 1/2/21 was issued in the exercise of Section 9(2) of the Land Acquisition Act 1965 for acquisition of the land. Therefore, the learned additional AG submits that the due process of acquisition has been initiated. Countering such arguments, the learned counsel for the petitioners submits that they have for the first time come to learn that a notice has been issued. However, no paper publication as required and personal notice has been issued. That is the case, Your Lordship. None of the landowners have been notified at all, even till today, actually. Regarding the survey, the learned AAG on instructions has submitted that petitioner number 1 by acknowledgement has declared a survey was conducted in his presence. To this, the learned counsel for the petitioner submits that a survey was done only for the purpose of identifying the owners of the land and not for the purpose of valuation of the property. Be that as it may, all these disputes can be answered once affidavits are filed with the answering respondents in the subsequent proceeding of this court. In view of the aforesaid, let a notice be issued returnable after 4 weeks. The learned counsel for the state respondents accepts notice on behalf of respondents. The Union of India is represented by Mr. Gauhati, the learned counsel is present. As the respondents 3, 4, 6, and 7 are duly represented, the state counsel new forms need to be issued. However, extra copies, etc. Notice to the respondent 2 has been issued to register post. In the interim, the last paragraph, it is directed to respondent number 7 that the land of the petitioner shall not be taken over without proper survey to be carried out in the presence of the petitioners. So here also survey was done, survey was done based on the orders of the court. Now, in Lordship, if you can come to the prayers in this petition, page 40. Page 40. Page 40. WPC 50, petition. This one is the petition. Is page 40, my lord, in WPC 50. Yes. Yes. Page 40. Yes. Direct the respondents to acquire the lands for the petitioners required for the construction of the Kohima Bypass Road project under packages 3 and 4 in terms of the provisions of the National Highways Act 56, the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013, and the Land Acquisition Act 1965. So this is the sole prayer here, Your Lordship. Because what was happening here, Your Lordship? At page 65, Your Lordship, you can kindly turn to page 65. 64 is original and 65. 65 is a typed copy. Your Lordship got it? Yes. May I read, my lord? Yes. Minutes of the meeting held in the office of the Deputy Commissioner Kohima in connection with the acquisition of land for construction of Kohima 4-lane bypass. Again, Your Lordship, a kindly note, this is not an acquisition proceeding. It is a meeting. The meeting was convened and chaired by the Deputy Commissioner Kohima on 2nd February 2019 at the DC's conference hall. At the outset, the chairperson welcomed all the members. The objective of the meetings was to discuss on the issue of land compensation in connection with the Kohima 4-lane bypass. The chair informed the members of the urgent and immediate nature of the project and also informed all about the classification of various land rates of the ongoing Kohima 4-lane project. The village councils, again, Your Lordship may also note, is the village councils who were present. Landowners were not present. The village council were of the opinion that there was only one meeting held till now for the said project and were not informed properly by the then DC and NHLECL of the alignments. They also added that the land rates given for the Kohima 4-lane were fixed in the year 2013 and was not acceptable to them due to the escalation of land rates in and around Kohima town. Better land rates were sought and requested for to make it acceptable to the landowners. Now, the point here again, Your Lordship, another point which I may make. In the previous case, only damage compensation, no land compensation. Here, land compensation. The village councils also requested for compensation for the community roads constructed by the villages in the respective CALs and villages. The village councils also raised the concerns for the agreed link roads which are in existence and are likely to be affected during the earth cutting for the project, and they further requested for restoration, reconstruction for the same once the project works are completed. After thorough deliberations, the village authorities agreed to propose for land compensation. Accordingly, the rate of land compensation was worked out and fixed. The categories of land as well as rates are given. This, Your Lordship, arbitrary decision, absolutely arbitrary decision. In the absence of the landowners, without following the procedure prescribed by law in terms of the National Highways Act. And this is just meeting, these are just meeting minutes, Your Lordship. Yes, meeting minutes. Just meeting minutes. So in this case, this is our case, Your Lordship. So in both cases, Your Lordship, very short point as far as the law is concerned. Can the NHLECL, the MRTH, and the state take over my property for the construction of national highways without paying me compensation? Compensation in terms of the provisions of the National Highways Act the Right to Fair Compensation Act 2013, and the State Act of 1965, which also refers to the Land Acquisition Act. That is the short point, Your Lordship. And now, with the intervention of this Honorable Court, survey has already been completed. All that remains is for the authorities acting under the provision of the National Highways Act to assess compensation and compensation be paid to me. And may I humbly pray, Your Lordship, that this exercise, it has been gone on long enough. We started this in the year 2021. We're in the year 2024, Your Lordship. On this short point of law, the state as well as the MRTH and the NHLECL should not have delayed for such a long time. Within a short time frame, Your Lordship, if I may pray, Your Lordship, within a short time frame, the respondents, MRTH, the NHLECL and the state, may be directed to complete the process of acquisition in terms of the National Highways Act 1956. That is my case, Your Lordship. And an IA has been filed. IA has been filed in which one? In WPC 50 of 2022.
Okay.
And this has been filed by the NHLECL, saying that the petitioners are obstructing the construction works. We have filed our affidavit of objection, affidavit of opposition, and we have denied obstructing the works. Short point. That is all, Your Lordship, in this way. That is all. May I rest for a moment, madam.
Yes.
Your Lordship, I represent the state respondent. I have a humble submission before Your Lordship that the matter will be continued after lunch. We have a few minutes left.
I never tell you. Yes, yes. No, beginning was. I thought you were saying, winners. What did I do? I don't know. Tell you. The name is in there, but we didn't tell you. And then senior government. Yeah. Next. Then number 2, the name is there. Yeah, for this. Item number A on the council, appears for petition. Item number 22, very soon. I'll change the petition to this pages. After the 21.
Print that page for you. One, right? I don't know, 22 wala page na? No. This start. Okay. 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 Very senior. Representing one job. Senior. This is the senior. This is the senior. Okay. Engineer. Not assistant. Engineer. Engineer. Oh, he appeared on the. I think her name is Channel. Common advocate name list we gave her last time. On behalf of. Not here, they are featured. The channel. The channel. List of common advocate name. Yeah, I'm looking here, you can take this to them. Yeah, I feel it. But you know, say, yes, we shall. Yeah. Okay, on behalf of Mr. P. Yes, Jimoni. You always doing it, yes. Yeah, the child, like the same Jimoni, the same. This one also, 25 also. This is the lady, Miss H. And this side same. उसके बाद 28 this post case na you have to get one also na 28 and long was there I January was there and for government was some. So I think it's edition 80. Yes. Status. Call me if you need anything.
Break time is streaming there na. Break time is streaming there na. Today na.
Jadi adnan lihat di sana, Nyoto siapa versus Adnan, right? Sip. Okay. So in this cases, they are in the main because they are integrated with their IP. So what about not 671? I think one order pass for everything. One order pass for everything.
Yes. please, sir.
Lordship, I beg to mention item number 34 to 38.
24 to
34 to 38. I'm yet to receive instruction.
My lord,
yes. Yes.
my lord, the matter has been listed for interim consideration. So, my lord, if my learned friend does not have the instructions, it can be listed for interim consideration next week, lordship. At least for the interim consideration.
After 2 weeks, I'll take it. The your government advocate,
Lordship,
the learned counsel for the state respondent submits that he is yet to receive instructions. And on that ground, the learned counsel prays for an adjournment. I have also heard the learned counsel for the petitioner. The learned counsel for the petitioner submits that today the interim prayer was to be considered. After hearing both sides, the matters are adjourned. At least after 2 weeks. On the next date, the prayer for interim order shall be considered. 34 to 38, same order.
Yeah, please.
Yes.
Since all the matters are analogous, my lord, it can be tagged together, lordship.
All these matters shall be tagged together.
Right, lordship.
May I please, your lordship? I beg to mention item number 46 and 47.
46 and 47.
Lordship, in item number 47, we are yet to file our Babla Namad, so kindly grant us 2 weeks time to file our Namad.
You have not filed a ballot number. You are the petitioner. In item number 47, you write the order. The learned counsel MS appearing for the state respondents has submitted that she is yet to file the Wakalat number and therefore prayed for some time to file Wakalat number. I have also heard the learned counsel for the petitioner. The prayer of the state respondent is allowed. List this matter after 2 weeks along with item number 46.
Please, your lordship.
Yes.
Lordship, as per the order that, I beg to mention item number 42. As per the order dated 4/10/24, we have already issued notice upon respondent 7 on 15/10/24. However, it's still awaited, so kindly let this matter come up after 2 weeks, lordship.
Notice not served.
Yes, lordship.
Heard the learned counsel MS.
K. Liliso.
Appearing for the petitioner. Service of notice upon the respondents is not yet complete. Therefore, await for service report. List up to 2 weeks.
Much obliged.
Yes.
Just so that the state, the respondents on our side, have no illusions about the applicability of the National Highways Act and the Act of 2013, Land Acquisition Act. It is a decision by this only court, a very old decision, Your Worship. It arose out of a marital dispute between two indigenous inhabitants of this state. And it is about the applicability of the Divorce Act of 1869. This matter went up to the Supreme Court, it was remanded, and it was finally disposed of by the Supreme Court. Your Worship, this is 1986, 2 GNR 296. 1986, 2 GNR 296. And this is about the applicability of the.
This must be there in the Nagaland code.
Yes, it was there. So this is in tune with section 26, which I was referring to earlier, Your Worship. All laws enforced prior to the grant of statehood would continue to apply unless repealed, modified, etc. Now,
This is not required. Other judgments you have given, they will cover everything.
Yes, Your Worship. But just in case, if Your Worship wants any authority on section 26, because this is an authority under section 26 of the State of Nagaland Act. And it says earlier acts in operation prior to the grant of statehood will continue to apply.
Yes.
So by that very logic, Your Worship, this Indian Divorce Act of 1869 was also deemed to be applicable. On that point, Your Worship. Not necessary, no?
Okay, all right.
And then the last point, Your Worship, this is from the Constitution itself.
Mm.
7th Schedule,
Mm.
entry 23,
Yes.
National Highways, list 1.
Mm.
It's a central subject.
Mm.
Just that much, Your Worship.
Mm.
7th Schedule, list 1, entry 23,
Seventh schedule,
list 1,
list one, yes.
entry 23. Entry 23. Highways declared by or under the law made by Parliament to be national highways.
Mm.
So it's a unit, it's a subject into the union list,
Ah,
national highways.
yes. Highways declared by or under law made by Parliament to be national highways.
Yes, ma'am. That's it, ma'am.
Yeah. Yes, please start.
Your Worship.
Yes.
Your Worship, these two projects, Kohima bypass and Kohima Chisami. Those two projects are, it is owned by the board, Ministry of Road Transport and Highway. And in put the project, we are the only implementing agency, we are the facilitator on the ground. So Your Worship, here, and those two projects, in those two matters, more than 200 landowners, they have accepted, most of them, they have accepted their damage compensation. So the landowner, those who are not agree with the damage, they come forward before they are on court. So Your Worship, here, my humble submission before Your Worship is right to fair compensation, this Act 2013. It is not applicable in the state of Nagaland. In view of the Article 371A, clause A, subclass 4.
Give me the book. Right to fair compensation 2013. Section,
Article 371A,
the section,
clause A, subclass 4.
section
Article 371A
of the Constitution.
Constitution of India,
Oh, section. Article
371A,
371.
special provision with respect of the state of Nagaland.
Yes.
Your Worship, here, unlike in other state, and the mainstream, Nagaland state is a very unique. So also the then holding system also very unique. So here in the clause A, subclause 4, ownership and transfer of land and its resources. In order to protect the landowner and its resources, unless
No, which is the clause?
clause A, subclause 4.
Clause A4, yes, ownership.
Ownership and transfer of land and its resources. So unless Assembly pass a resolution, Legislative Assembly of Nagaland pass a resolution adopted a particular law pertaining to the land ownership and its transfer, then that cannot be applied in the state of Nagaland, unlike other state and the rest of the country. So basing on that, Your Lordship, here, that is another provision. Here, again, Your Lordship, here, the Ministry of Road and Transport and Highway, they have issued one comprehensive guideline. That is, in my affidavit dated 31st/8/2024, my affidavit, Annexure 3. And in the repetition also, that is Annexure C.
Where is the affidavit?
My affidavit is dated 31st August 2024.
Affidavit in opposition.
And repetition that Annexure C. It's one number 3, 4, 5, and 6. I think that's the one, that's all. Yeah,
This one,
annexure 3. Yes, annexure 3.
annexure 3. DPR presentation
No. Annex,
or DPR presentation.
annexure 2, sorry, annexure 2.
Comprehensive guidelines,
Yes, yes. It is issued by the Minister of Road and Transport and Highways.
page 21.
Yes,
Yes.
starting from page 21.
Hmm.
And those contents has been clearly explained by the learned counsel of the petition also. So, Lordship, I would like to draw your attention of the Honorable Court to the clause 7.2. Clause 7.2. Page 31.
Yes.
Clause 7.2. 2, subclause 3.
3 yes.
May I read?
Yes.
Your Worship here, however, considering the urgent need of minimizing litigation and ensuring early availability of the land for completion of the National Highway projects, land for National Highway project can be procured through direct purchase with the consent of the landowners in accordance with the Accession Act, rules, policy of the concerned state government, subject to the condition that the total amount of compensation so work out will be no more than what is payable when the land is acquired under the National Highway Act 1956, which in any case is in conformity with the compensation payable in accordance with the provision of RFCTLA Act 2013. So in this clause, in this particular clause, the ministry, they have given one option to the state. So option is in accordance with the existing acts, rules, policies of the concerned state government. So in view of the unique legal system, so we have adopted the policies of the concerned state. We have asked for a policy since the scope is given in that comprehensive guideline, we have opted at the policy. So your worship here, whatever amount we have fixed, assessed fixed for the damage compensation, it is done as per the provision of law. That is under the Nagaland Regulation Act 1965. And now the petitioner approaching this honorable court for the land compensation. So our policy, as per this guideline, our policy, which is incorporated in the clause 7.2, our is we just not basing on the existing act or rules, but we have based on the policies of the concerned state. So we have, in view of the unique land hold system, we have based on the policy of our state. So we have done, and since we have just based on the policies of our state, we have not touched the National Highway Act or any other law, because the guideline itself is they have given a sufficient scope provided to us. So accordingly, we have given the damage compensation. So almost all the landowners have accepted the damage compensation. Whereas in our policy, we have not adopted for the land compensation for the road. So that is one of my submission. And again, now in the present matter, the petitioner is not assigning the rate, the assessment and putting up the rate of the damage compensation. But so far we have done only for we have worked out only for the damage compensation. So we have based on our own law, Act 1965, and since we have our own law and basing on, as I stated, basing on our own policy, we have not touched a Highway Act nor the right to fair compensation. Because right to fair compensation is it is not applicable at all It is not adopted by the Nagaland Legislative Assembly. But in order to meet the urgency of the connectivity, we have adopted our policy and we have passed on our policy and we have assessed the land compensation, but not for the land compensation. And the question raised by the learned colleagues of the petitioner is such that the landowner, the state respondent, they have now obtained no objection from the landowner, only for the council. So why we have obtained the no NOC from the police council only? Because all those respective police, respective landowners, they are under the administrative control of the village council. So we have obtained the village council. In a certain case, the landowner agree, but because of something unavoidable situation, village council also objected. So the matter could not be materialized. So in order to avoid all those things, we have taken the council, and when the village council is there, it involves all the landholder and non-affected landholders also. So whatever we have done, that is my only submission. That whatever we have done, as per that clause 7 of a comprehensive guideline, we have brought out. And if the prayer of the petitioner is allowed by the honorable court, so we are only implementing agency. We are facilitating on the ground. So if at all the honorable court decide to pay the compensation or decide to give the direction for the compensation, this has to be done by the owner of the project, that is a ministry. So, Your Worship, that is my brief submission.
My lord, I'm for the respondent one and two, both the WTCs. I'm for the initial. You want to? I'm for the more as well as
NHS.
My lord, here, in the WPC 216 of 2021, the meeting was held on 21 November 2018, as stated by the learned counsel for the petitioner. And then in this meeting, the state government has communicated to us about this existing state policy, where there is a policy of, it will be in my affidavit in the position, page number 49. WPC affidavit position on behalf of respondent one and two.
What is the date?
18/4/2022.
Page number?
49. My lord. It's the last page.
Yes.
Here, the learned counsel for the petitioner, he has already read the whole thing. But my lord, I want to reiterate the point where a conscious decision was taken to include compensation of land only for the greenfield portion of this project. As you are already aware, making available land free of cost for two land road development projects on the existing alignment is still being applied to all NHIDCL projects in the state. So, my lord, this has been conveyed to the NHIDCL by the government agencies that there shall be no land compensation. Only damage compensation will be given in the projects of where two land projects have been undertaken by the NHIDCL in the state of Nagaland. My lord, here my humble submission will be that damage compensation has been estimated by the revenue department. The state government has approved the rates which are specified in the schedule of rates. And accordingly, the ministry has released the fund. Acquisition of land is the responsibility of the state, where all the NOCs were submitted by the VCs as well as the district commissioner, deputy commissioner, and police.
Yes.
Yes, my lord, again, when it comes, coming to my pairwise reply, page number 10, point number 7, page number 9, I'm sorry.
Yes. There are 6.
There are 7.
7.
Point number 7. Acquisition of land has not been made as the National Highways Act 1956 is not applicable in the state of Nagaland. The Deputy Commissioner Kohima, after due verification, the damage compensation estimate prepared by the Revenue Department, State Government of Nagaland, has approved the rates specified in the schedule of rates SOR by the competent authority of the state. Accordingly, NHIDCO deposited an amount of rupees so in the joint account of DC Kohima and General Manager Projects Procedural, and rupees so in the joint account of DC Tech and General Manager Project Procedural for disbursement of compensation to the legitimate beneficiaries and affected landowners. Hello, I would also like to come to point number 9.
Yes.
That as regard to Paras so regarding acquisition of the land for the construction of the land with hard shoulder of Kohima Jasami Road on National Highway 29, all National Highway 150 from existing so and so to existing so and so near Chakabama design so and so in the state of Nagaland under Baratmala Pariyojna, the National Highways Act 1956 is not applicable in the state of Nagaland as the land and resources belong to the people under provisions of Article 371A of the Constitution. Hence, the land in right of way is not acquired by NHIDCL for development and maintenance of road. However, properties of respective owners falling within the proposed ROW are assessed for damage compensation as per approved rates in terms of the rate specified in the schedule of rates by the concerned authority of the state government of Nagaland. It is also submitted that the allegation made by the petitioners are totally baseless as no law has been violated by the respondent number 2 NHIDCL. The entire project is being executed by the respondent number 2 by observing due process of law. My lord, my short and humble submission in respect of WPC 216 is that the land acquisition has been done by the state missionary. The schedule of rates has been fixed by the state missionary, and accordingly, we have calculated all the as per the schedule of rate, and then accordingly the fund has been released, which is in the joint account of the DCA as well as the project monitoring unit.
These 2 roads are situated in which district? Kohima
With 2 ones, the case pertains only to Kohima district.
In Kohima
However, that with respect to the project of which falls under 216, it covers both Kohima and Tek.
In the district of Kohima.
The petitioners are from Kohima and then
Some
the
portion of
package.
the road goes to Peg districts.
No, but this Nagaland court says that the Land Acquisition Act 1894 shall be in force in Kohima and Mukoksang district only.
No, if your lordship will see the heading, list of central acts in the schedule, before the schedule, applicable to the Naga Hills Fencing area.
List
Prior-
of central acts in force
Yes,
in erstwhile Naga Hills,
Naga Hills,
Tuensang area,
yes,
immediately before 1st December 1963.
yes. So by virtue of these acts being enforced, they are now applicable to the entire state now, your lordship. Now to the entire state.
Before 1963, it was applicable for Kohima and Mukoksang only.
For my moksha.
Now,
Now, by virtue of 1962,
Ah.
state of Nagaland in 1962 becomes applicable to the entire state. The entire state.
okay, then another thing, this constitutional provision, what is your reply to that?
That is why, your lordship, even
371.
the Indian Divorce Act of 1869, that plea was taken. And that plea was considered by the Supreme Court. It is real judgment. Yes. If your lordship can come to page 305. 305. This is in relation to section 26 of the State of Nagaland Act.
Para?
There's no para number, your lordship, in the middle of the page 305.
305.
Yes.
Oh, it's-
The contention of the learned council, has the lordship got that?
Ah, yes, yes.
The contention of the learned council relying upon the provisions of Article 321A of the Constitution providing that no act of parliament in respect of Naga Customary law. So Naga Customary law is also one of those clauses under 371A.
Yes.
And no act of parliament in respect of Naga Customary law and procedure shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decided need not detain us long in view of the express provisions of section 26 of the State of Nagaland Act 62 and the further fact that the Indian Divorce Act 1869 is not an act of parliament to which the provisions of Article 371A of the Commission of the Constitution is enshrined. So by virtue of section 26, your lordship, the Indian Divorce Act of 1869 was in operation prior to statehood. So by virtue of section 26, it continues to be in operation. This is the decision of the Supreme Court, your lordship.
Okay. Land Acquisition Act. (1894). It is not an act of parliament.
The Land Acquisition Act,
Earlier Land Acquisition Act 1894.
it is an act of parliament, your lordship. It is an act of parliament.
But at the time of 1894, the British government was ruling.
Yes, your lordship. So 1894 was in operation till 2013, your lordship. It was adopted by the parliament.
Oh, yes.
Yes. It was adopted by parliament. Similar argument was raised during the hearing of this petition. That by virtue of 371A, the Indian Divorce Act of 1869 does not apply. So this honorable court held that no, it does apply because of section 26 of the State of Nagaland Act. And not only that, your lordship, 1869 Act is an act of parliament. National Highways Act is an act of parliament. Right to Fair Compensation Act is an act of parliament. And it has been adopted by our state. After you finish, I'll reply with some short notes.
Yes.
Your Honor. My lord. Coming to this WPC 50 of 2022. There in by virtue of the same letter dated 6 August 2020, which we have read in the earlier case. Here also all the process are more or less the same with regard to acquisition of land and fixing the schedule of rents. However, in this project, the Kohima bypass road, certain consideration has been given. Here in the WPC 50,
Yes.
land compensation was to be considered because of the high rates around the capital city. So here, here in this WPC 50 of 2022, the mesh compensation was not considered, but instead of that, land compensation has been fixed and has been fixed by the state agencies. So that is the only slight difference in both the cases.
But in the, there is a guideline for procuring land by this transport ministry.
Yes. Yes.
They have said that guideline says that you have to purchase the land. In order to acquire the land, you have to purchase it.
Yes, my lord. We have to purchase the land, or if there is an existing state policy, we are to follow that state policy. So there is an existing state policy back then, by virtue of this letter dated 6 August 2020, and accordingly.
Which is the letter? Have you, if in opposition, you must have filed this.
Page number 49.
49. Where is not there?
In the affidavit of opposition in respect to WPC 216.
Or WPC 216. Affidavit in opposition. Page number?
49.
41.
49.
49. Yes.
My lord, if I may be allowed to read the whole page again.
Yes.
Dear Shri So, I take this opportunity to convey my deep appreciation for the sincere efforts taken by your team on road development projects in the state. Despite setbacks due to the COVID-19 pandemic, the indomitable spirit put in by the NHIDCL has been most commendable. I would like to draw your attention to the necessity of development of Kohima bypass and Kohima Mau road as discussed with you on date so. Here, the WPC 50, the project is the Kohima bypass road.
Yes.
Subsequent to the downgrading of Kohima bypass project from 4-lane to 2-lane, it has emerged that the farmers affected by the project are reluctant to part with their land without customary compensation, as cost of land around the capital is assessed to be high. After a series of discussion by administration with landowners, it has become difficult to completely ignore the land compensation part of Kohima bypass project. Appropriately keeping in view of our existing policy of non-applicability of land compensation on road projects where existing alignments are adopted for development. A conscious decision was taken to include the compensation of land only for the greenfield portion of this project. As you are already aware, making available land free of cost for 2-lane road development projects on existing alignment is still being applied to all NHIDCL projects in the state. You will appreciate that this bypass is imperative in view of heavy vehicular traffic to and from Imphal on National Highway 29 through Kohima City, which has increased manifold due to law restriction imposed on Imphal-Jerebam Road, leading to heavy congestion within the city. It will also be appreciated that with the aim to have faster development of intrastate connectivity projects, provisions of land free of cost for 2-lane projects in Nagaland has been adopted, unlike that in any other state. Therefore, minor variation of land policy with respect to greenfield projects need to be considered at par with policies of land compensation being adopted among other neighboring states. May I therefore request you to consider compensation in lieu of land for Kohima bypass portion passing through greenfield and apply free
land policy on alignment passing through existing road, where only damage compensation is to be catered. I also assure that judicious land rates will be applied within the normative laws in the state for this project. In view of this, I request your personal intervention for speedy implementation of Kohima bypass. Also, the Kohima Mall sector may kindly be taken up in order to provide seamless contour. So, my lord, this, by virtue of this letter, the state government has communicated the ministry as well as the NHIDCL that land compensation, land for two land projects which are being undertaken by the NHIDCL in the state of Nagaland shall be free. However, for the Kohima bypass road, land compensation may be considered. That was being conveyed to us. So, in regard to the existing state policy, which has been determined by the state government, and then all the fixation of rates as well as the acquisition of lands were the responsibility of the state government. And this was communicated to us through this letter as well as other letters. So accordingly, we have calculated the rates and then we have deposited amount. And then many of the landholders as submitted by the learned AG have taken up the compensation. That will be my humble speech.
Please, my lord. Occupying for respondent number 7 in 216 of 2021. Lordship. I've been included as a party by virtue of the fact that I have issued one no objection certificate, which has been referred to by my learned senior colleague.
No, but a village council.
Lordship.
Village council.
Lordship, no, actually, I wanted to make 2 submissions, Lordship. The first one is that I am not the village council. I'm not a statutory body, Lordship. I am a KEL council, Lordship. It is not a statutory body per se. It has been there to look after the interest of the members of the KEL. And insofar as the NOC which I have issued, Lordship, I have issued this merely to facilitate and to ensure smooth execution of the project, Lordship. And as my lord has questioned earlier, second point is that I do not represent the village council.
Lordship, firstly, settled law, settled law. Article 308, no person can be deprived of his property save by authority of law. What is the authority of law? National Highways Act 1956, Right to Fair Compensation Act 2013. By a policy decision, by exchange of letters between NHIDCL and the state government, can Article 308 be violated? Can National Highways Act 1956 be violated? Can the Right to Fair Compensation Act 2013 be violated? Can the rights of landowners under the constitutional provision and these acts be violated? No, Your Lordship. That is settled principle of law. Not at all. And so far as the letter of 6th August is concerned, I have placed the letter, Your Lordship. It has been withdrawn. It has been withdrawn. We have realized the error of their ways. They realize that they must pay compensation both for land as well as buildings and property. And this is the notification dated 28th November 2021-23. It was placed separately, Your Lordship. Has the Lordship got it?
Yes. No, there in Article 371A, there is a line here. These nothing will be applied unless the Legislative Assembly of Nagaland by resolution so decides.
So decides.
So this is the decision of the
Yes.
Nagaland Assembly.
Yes. This is the Nagaland Code, Your Lordship.
Yes.
Issued by the Nagaland government.
Yes.
And these are the acts which we have taken to be as enforced from the date of statehood, unless repealed, modified, altered, etc., etc. And the notification of 6th August, which the respondents 1 and 2 are relying upon, which they say is a policy, Your Lordship. As I was saying, submitting, Your Lordship, this policy cannot override 300A, the National Highways Act 1956, and the Right to Fair Compensation Act 2013. Plus, the notification itself has been withdrawn. Now, Your Lordship, in the comprehensive instructions, my Lord, we again come to the writ petition in 216. 216. We state the same that the acquisition proceedings will have to be done by the center And the center, respondents 1 and 2 are saying the responsibility for acquisition proceedings rests in the state. Now, if the lordship will come to page 45 first. The paragraph which the learned additional AG was relying upon.
Yes,
Page 45.
yes. Clause 2.
7.2, can we start from the beginning, Your Lordship? Clause 7.2. In supersession of the above OMs, it has been decided by the competent authority that following guidelines shall be followed henceforward with immediate effect and until further orders regarding bulk acquisition, purchase of land through consent of landowner. So competent authority is who, Your Lordship? Competent authority is MORTH. One, there is a specific central statute for acquisition of land for national highways. National Highways Act 1956. As such, legally, the central government and its authorized project executing agencies are competent to acquire land for the constitution, construction, development of national highways under the NH Act 1956. And the states do not have a case to insist that the land for national highways in their jurisdiction should be acquired under the statutes policy framed by the state governments in the territory administration. Very clear, Your Lordship. This is also in terms of the law. It is the central government who will acquire. The state government cannot insist that according to its policies, according to its law, land should be acquired. No, the responsibility lies with the central government. And this counters the argument raised by the central government that it is the responsibility of the state. No, under the National Highways Act, the responsibility lies with the central government. The compensation must be paid by the central government, not the state government. Then 2, the specific clause which the additional AG was relying upon. However, considering the urgent need for minimizing litigation and ensuring early availability of land for completion of the NH projects, land for NH projects can be procured through direct purchase with the consent of landowners in accordance with the existing acts, rules, policies of the concerned state governments, subject to the condition that the total amount of compensation so worked out will be no more than what is payable when the land is acquired under the National Highways Act 1956. So compensation cannot be higher than the rate under 1956. And 1956 will be under the Right to Fair Compensation Act 2013, which in any case, this is important, Lordship, which in any case is in conformity with the compensation payable in accordance with the provisions of the arrears Act of 2013. So even if the state government, Your Lordship, kindly note this point, even if the state government does the acquisition process through its own policy, it must be in conformity with the Act of 2013. Now, page 47, Your Lordship. Page 47, clause 10. Who is the competent authority? Competent authority for land acquisition and due diligence at the time of determination of compensation amount by the competent authority. The central government, that is Ministry of Road Transport and Highway, appoints the competent authority for land acquisition in exercise of its powers under Section 3A of the National Highways Act 1996. As such, the competent authority for land acquisition appointed by the state government is obliged to take all action for acquisition of land under the National Highways Act 1996 and the guidelines issued by the central government on the subject. So who is the competent authority? Usually, Your Lordship, for determining acquisition, for determining compensation under the National Highways Act 1996, it is usually the district collector, deputy commissioner. So not the central government, not the state government. My apologies, not the state government. The central government must do it. Very conveniently, the central government is relying on a letter, not also any policy, just a letter issued by the central government. And they're denying the rights of the petitioners in total violation of Article 308, Act of 56, Act of 2013. Then last, Your Lordship, page 64. This is again very interesting, Your Lordship. There is an abstract in this comprehensive guidelines. There is an abstract of how the acquisition proceeding should proceed. 64. A, land acquisition proceedings. First step is Section 3A of the National Highway Act 1996, notification of competent authority for land acquisition by the ministry on the recommendations of the state concerned. Involves no administrative costs. Then 2, Section 3A of the National Highway Act 1996, preparation of the notification, issue of initial notification containing the brief description of the land. Then 3, further requirements and lordship. Then 3, action under Section 3B of the National Highway Act, survey and investigation of the land. So survey is already done, my lord. In both cases, survey is already done on the direction of the zoning code. 4, Section 3C, invitation, examination, and statement of objections received, filed by the landowners, interested person, etc. But 1, 2, and 4 is yet to be done. Then 7, declaration of position. 8, power to take possession, of course, with the reference to the sections of the National Highway Act. 9, entering upon the land resting in the central government. Land has already been taken. 10, determination of amount payable as compensation. And next page, Erosion. Deposit and payment of money. So step-by-step procedure, Erosion. Step-by-step procedure in terms of the prescriptions on the National Highway Act. None of these steps have been complied with today. That's all. What's your name?
Order is reserved.
Where?
For hearing, item numbers 43 to 45.
I'll take my home.
Yeah, please, Your Lordship.
Yes.
My apologies, but in item number 42, there is an interim, Lordship.
Item number 42. The interim order pastel will continue until then. Item number 43 to. Come to my residence. Who is for a petitioner here? Item number
43 to 45.
3 to 45. I will take it on some other day. Because today I have heard the one long matter.
The other counsel for the respondent. Coming from leading his concern also whether we can take up. You'll be in position to pick up on that, any other coming dates or that.
Who is the counsel?
I will put the petition on my own.
You put a petitioner.
My seniors.
I will take these 3 meters on some other day. Today I have heard a long matter. I have to write the judgment also.
Then your lordship can be on Thursday or Monday. Tomorrow I have a matter.
Okay. Okay. Then next Monday?
Monday, my lord. Okay.
Next Monday. I'll list this matter. On next Monday, give the date. But what will be the date?
25th.
25th. For hearing. 3 matters. You write the order in item number 43, list on 25 November, along with item number 44 and 45. Because I have heard a long. It will take some time. I think. Okay. Yeah.